permission to mention item 29, your lordships. I am seeking upgradation of item number 29.
Why? There's a stay order.
Yes, my lord. In item 29, I am seeking upgradation, my lord.
No, no, no. When the matter is.
It's not audible, my lord.
No upgradation. When the matter reaches, we'll take it up.
Yes, my pleasure.
I seek your lordship's permission to mention one item, item 32. I have an appointment with the dentist matter at 12:30, so I want to go at 12.
Huh?
I have an appointment with dentist, so I have to leave at 12.
Hmm.
32. 32.
Yes.
It will come next week, but tomorrow day after.
Interim order?
No.
So we'll have it after vacation. At the request of Mr. R.P. Sharma, the Learned Senior Counsel, the matter stands adjourned to be listed after vacations.
Item number 49, that is up for hearing. In fact, we want to withdraw. I mentioned it yesterday in court number 12. The insurance company wants to withdraw this appeal, not debt. So can it be upgraded or can it be upgraded because it is?
You want to withdraw?
Yes.
Okay,
That
withdraw, we
I have
allow it.
Yes.
R.D. Majumdar, the Learned Counsel, appearing on behalf of the appellant, submits that she has instructions to withdraw the instant appeal. Accordingly, the appeal stands closed on withdrawal. Interim orders, if any, stands vacated. Mr. Argusami appears on behalf of the respondent number 1. No, why? Have you deposited the entire amount?
No, no. Please state.
No. Have you deposited the entire amount?
That-
It is further observed that upon deposit of the entire amount, awarded amount along with applicable interest before the learned tribunal within 6 weeks from today, and the acknowledgement thereof being produced before the registry of this court, the applicant would be, the registry shall refund the statutory deposit.
Your Lordship, and the LCR, the worker record may kindly be.
The LCR be returned.
Highly obliged.
Correct, Rod. I would like to mention item 46. It was listed on Monday. There's an interim order on in the favor of the petitioner, and I had it did not reach on Monday, Lordship. As per your Lordship's direction, it was listed today. My only prayer is it can be taken up today, even if it has the last
Okay, we will take it up.
Lordship. And thank you, Lordship. There's a small affidavit which I have filed in the matter, Lordship. With the
May I please, my lord, item number 35, my lord. We are supposed to file an undertaking, my lord. But because of flood, my lord, the petitioner could, otherwise, my lord, affidavit is ready, my lord. Petitioner could not come, my lord, to fire the affidavit, my lord. And there is stay order in favor of the respondent also. Stay order in favor of the respondent.
You are for the respondent.
I am for the petitioner in the main CRP, my lord.
Mr. A.H.M.R. Chaudhary request for an accommodation on the ground that the additional affidavit could not be filed today. List the matter after vacations.
May I please, Lordship? I beg to mention item number 15, 15. In this case, I'm going to file the Wakalatnama, my lord. But as per Honorable Court Order 8/1/2025, we have communicated with the appellant, my lord, and accordingly they came and signed the Wakalatnama. We're today going to file the Wakalatnama, but the file is not also with us. We have to, my lord, reconstructing the file.
You have not filed the Wakalatnama. The file is not with you.
My
Who
lord,
are you?
I am not in the case. The case
So
was.
you are
the
nobody,
Mr. Prafulla Roy, it
so
was
you are
expired, my lord.
nobody anywhere.
My lord.
You are a stranger. Why should I adjourn it on your behalf?
But my senior was there, Mr. Prafulla Roy, but he was expired. In the
So
meantime.
I can't help you. We'll see when the matter
Why not?
reaches, you be there.
Obliged.
Item 38, Lordship, we made a mention for listing. Can it be upgraded, Lordship? It's
What?
more- My second suit was state, Lordship. Section 10, application of the respondent was allowed, Lordship.
Is a hearing matter?
Lordship, it is an admission matter.
Why did hearing
After
matters?
completion of service matter listed in hearing, so it was listed in hearing column. But in fact, it was not yet admitted, Lordship.
Shall we
Sim-
take it after the stay matters?
Lordship, similar item 50 also, Lordship. Same here also, it was not admitted, Lordship. And in fact, in this case, Lordship, Order 21, Rule 97 petition was rejected against that CRP, and in fact, CRP is not maintainable.
How many hearing matters on a non-hearing day?
Lordship. 38 and 50, both are admission matters.
Chalo. But how do I take it? You are for the respondent.
Lordship, for Mr. Siladip.
Tell them that when the matter is taken up, we'll take it up after the stay.
Obliged. 3 PM, Lordship, item 38. Sir,
Why?
I have asked Mr. Nihal, he is for some personal difficulty, will remain present at 3 PM only.
Who?
Mr. N. Chaudhary. He is for the respondent in item 38.
Chalo. Take it at 4:45. 4:45.
Lordship.
Last item.
Last item, Lordship. Obliged.
May it please your honor, with item number 4 in the daily list and admission column, your honor, Mr. R. Senso, the counsel for the petitioner, his family member has expired yesterday, so unfortunately he had to rush back home from the other side as well. Can it be done for today?
What is this matter?
Your honor, it's a civil revision petition.
For what? Anyway, we'll take it up when the matter reaches. Don't mention this.
Your honor, can it be taken up at 2?
No. Item number 4 is item number 4. We give it importance.
Out of station.
Hmm?
My senior Mr. SKMG is out of station, so Lordship kindly adjourn the matter for the day.
We'll see when you do it. It's Union of India matter. So Union of India matter is very good. We should do it. Get hold of any Union of India council.
The petitioner is a casual employee working.
What?
Petitioner is a casual employee working since 2014 in MSCT Court, Gwalpar, my lord. The regulation is a issue, my lord, but apart from, my lord, what happened last month, my lord, the fixed pay 9,000 amount has not been paid, my lord, without any assigning reason, page 17, my lord. My prayer at this moment is that, my lord, the direction will be given to the respond number 3 and 6 to, my lord, release the fixed pay, my lord. Prior to that, it was released, bank account is there, and so far 4 and 5 are concerned, my lord. Instruction may be sought for about my regulation issue.
So without hearing the other side, I should pass orders.
My prayer.
Oh, no, what is that?
My prayer.
Your prayer, that is the final relief.
No, absolutely not.
That is the final
No,
relief.
my 9,000 is just a paper, which is not paid for the month of May, my lord. April till that they have paid, my lord.
So how do I know that
My
you
lord,
have not been thrown
My
out?
lord, my bank statement, my lord, I have enclosed.
No, you have not been thrown out. How do I know?
No, absolutely, I still working, man. Today still I'm attending the office, man. There is no doubt. I have made a statement, man.
Then
I made a categorical statement in that I'm working. Even suppose they terminate, definitely they will issue a notice to me, man. There is no need to that effect that I'm not working there till then. I made a statement, man, on affidavit.
you mentioned this where?
My lord, in paragraph, man, I'm saying, man.
Where, in which code did you mention this?
My,
item?
my,
Huh?
I'm making one.
Why did you mention it before court number 5? Go there. You'll get an order there. It's a high court matter. How did you mention it in court number 5? Go there. Let it be listed before that court. I can't help it.
I might the same alert this lordship this case alert.
No, you know that the high court matters are before this court by way of a specific notification. That? Okay. Should notice.
My lord, one thing, my lord.
Huh?
They are paying for regularization also.
What?
Yes, ma'am. And my lord, without making the state and the finance department party. No, finance department party. Finance department party.
Finance is party.
Yes,
Where?
That's one number 2, my lord. Three is the party, finance department.
Yes,
Why do you have
three.
not served copies upon the finance? Their names have not been shown.
But right now, let's stop.
Why haven't you served it? For 3 and 6, get hold of a finance council. We'll take it up after some time.
Okay.
Thank you, my lord. This is
Appeal has been admitted.
my lord. My daughter, this is T5 2019.
It is seen from the orders dated 3/12/2019 that both the appeals have been admitted. These are connected.
No, my lord. This has been filed by me against the impugned judgment order dated 18/12/2018. My, this is a cross settlement.
Connected. So both are connected.
Connected.
It is seen that by both the appeals have been duly admitted. First, considering the above, the question of the appeals being listed for admission does not arise. First, the registry shall list the appeals for hearing in the usual course. Liberty given to both the parties to file application for early hearing.
Okay, my, there is an IM, my lord, so the stay order is granted until further order. And they have filed an affidavit of opposition, I have not received the copy of the affidavit of opposition in the IM.
It is until further orders, no? You should be happy.
Yes, sir. God bless you, lord.
Hey, Puno. Yes, what is this?
Well, this application has been filed.
What you are challenging?
Rejection of my petition under section 65 of the evidence. Act.
What do you want to bring? Submitted
I
a
want to
petition
bring
on
on
the
secondary-
Iman to adduce secondary evidence to prove the original exchange deed needed on the basis. The ground of the said document that the original exchange is in the custody of certain steps taken. You are the defendant.
Yes, I
Well, what about the service upon the respondent?
it is complete. Their name is shown in the court.
Who appears for the respondent? Okay.
As you got
Okay. Therefore, heard Mr. A.P. Sharma, the learned senior counsel, assisted by so and so appearing on behalf of the petitioner. None appears on behalf of the respondent on call. Pusto. The present application has been filed challenging the order dated 2/9/2023, passed in petition number 63/2000/23, arising out of title suit number 56/2023, whereby
No, no,
2023, na?
no. 56 of 1993.
Huh?
56 of 1993.
1993 suit is going on.
Mother, the case was once
1993, whereby. Yes, you are appearing. What have, we should allow this.
Actually, so there is no existence. Initially applied for.
What is this exchange deed?
Exchange the lordship that it was not all, not mentioned the WS also lordship. The court are documents to be proved as secondary lordship. There is no pleadings at all.
No, it's
Yes.
okay, but have they enclosed the photocopy of that document along with the written statement?
No, no.
Then, without seeking a leave, you are seeking this.
Nothing, lordship.
facts are different. The plaintiff and the defendant are two brothers. The plaintiff sold the land to the defendant by execution in registered sale deed. And in the year 1960, after so many years, he filed a suit that sale deed is not admissible. It is not a proper sale deed because the plaintiff was minor at the time of the registration of the sale. That suit was dismissed. Then again, they preferred an appeal. The Lower Appellate Court remanded the matter to the trial court by framing one issue. Against that order, the other side came before the Honorable this court. And the second appeal was registered. In the second appeal, it was again remanded to the trial court to give a finding on the additional issue. While this matter is pending, the petitioner filed a petition for adducing secondary evidence to prove a deed of exchange between the plaintiff and one Sosindra Mohan. That prayer was allowed. When the notice was issued to the Sosindra Mohan, it is reported that he died, he is dead. Therefore, I filed a petition under section 565.
No, did you take the leave?
Yes. Page 35 will also.
Page 35. Yeah. No, understood. But where is the leave? If you have not mentioned it, you have not filed at the time of filing of the written statement, that document.
No, my lord, the everything arose after the remand of the case from this honorable.
You are the defendant.
I am the defendant.
So if you are the defendant, have you taken the plea as regards this exchange deed? In your
In
written
the
statement?
original written statement,
No,
was
in
not
have you amended written statement? Have you taken it?
I have not amended the written statement
Then the question is, how do you lead evidence in respect to this document?
because while remanding the case, the
But
court,
if
the
you
court-
are, but whatever may be, you can adduce evidence only to the extent what you have stated in your written statement. There has to be pleadings.
my lord, while remanding the appeal, remanding the case to the trial court, this honorable court directed both the parties to lead evidence.
Understood. Lead evidence in respect to that. But you want to bring in something that has to be basis of pleadings. I don't say, I'm not on that aspect, that you have mentioned about that particular document, and you did not say in terms with Order 8, Rule 1A2, that this particular document in question is in the possession of so and so. It may not have said that, or which was earlier required, because this is a suit of 1993. So at that point of time also it was required to mention this very aspect of the matter. But you may not have stated, so I am not on that. But the question is, if there is no foundation laid down in the pleadings, how do you adduce this document as a secondary evidence without bringing into account the original?
Malati, it is a subsequent development after remand of the case. Because in the particular time,
This
Yes, I-
document is of the year 1966.
yes, at
So
that
it
time,
cannot be a subsequent development. This document was very much there at that point of time.
on this document is necessary to prove that the plaintiff executed another sale deed in favor of by the on this in the year 1966.
So without there being foundation in the pleadings, how do you prove that? This
Madam-
document.
As the appellate court and the court directed the parties to adduce evidence.
Adduce evidence, whatever may be, adduce evidence cannot be has to be adducing evidence only to the extent which is there in your case, in your pleadings. That without there being a pleading, where is the question of evidence?
My lord,
There cannot be pleadings beyond evidence. The evidence beyond the pleadings. Settled.
my lord, here, in this case, my lord, after the remand, everything has been said. Both the parties were directed.
So
to-
without changing your written statement, you cannot bring in. Chalo, देखो, Mr. F.U. Borbuya appears on behalf of the respondent.
My lord, in that case, my lord, I will give some liberty to take necessary steps.
You think, whatever may be. The petitioner have challenged the order dated 2/9/2023, passed in petition number 63/2000/23, arising out of title suit number 56/1993, whereby the learned trial court refused to grant permission to adduce secondary evidence of the exchange deed number 580 dated 28/1/1966 on the ground that there was no foundation. Full stop. This court have duly taken note of the order passed, taken note of that in the written statement, the plea in respect to the exchange deed number 580 dated 28/1/1966 was not taken. First, it being a settled position of law that there cannot be evidence beyond the pleadings, comma, in the opinion of this court, the learned trial court, that is the court of the civil judge junior division number 2 Nagaon, was justified in rejecting the application being petition number 63/23 filed under section 65 of the Indian Evidence Act. Accordingly, this court does not find any merit in the instant application, for which the instant application stands dismissed. Full stop. Be that as it may, it is observed that full stop. It stands dismissed. Full stop. Be that as it may, it is observed that it shall not be a bar on the part of the plaintiff defendant, who is the petitioner herein, to take other appropriate course of law as available. Full stop. This court further finds it relevant to take note of that by an order dated 7/2/2024, the further proceedings of title suit number 56/1993 pending before the court of the learned civil judge junior division number 2 Nagaon was stayed. The said stay order stands vacated and the parties are directed to appear before the learned trial court on 14/7/2025 for further proceedings of the said suit. This court further observes that taking into account that the suit have been pending since the year 1993 and almost 3 decades have passed by, comma, and the learned trial court shall make an endeavor to dispose of the suit at an early date.
Apply.
Yes, what is it? What are you challenging?
Your Honor, the respondent as petitioner in the court below had filed title suit number 3912.
Huh?
We were the defendant number one in this, the title suit. And our point of contact with the council, the court,
And for
the trial
setting
court
aside
was
the vote
defendant
of
number
the
7,
judge,
Mr. Khagan Sharma.
and so maintain. Why only one person has only filed this application?
Your Honor, what had happened, even though I was the defendant number one, the sole contact with the defendants and the counsel was late Khagan Sharma. So after he passed away, we didn't have any.
How is Khogen Sharma into the scene?
He was defendant number 7 in the title suit.
Huh?
He was defendant number 7 in the title suit.
Then
We had no knowledge regarding his death, and eventually the case proceeded ex parte against us. And
when?
Your
When
Honor,
did the court proceed ex parte against you?
order dated 21/11/22.
Where is that?
Page number 92.
We will not proceeded ex parte.
And another 5/7/23, plaintiff is represented, none appeared for defendant as such DW stands closed. After the passing of these two orders, we filed an application under order 9 rule 7. So
Okay,
vacation of,
who has filed this application?
defendant number 1 in the tax.
Why others have not filed when the written statement has been filed by 1 to 7 together? Huh? What?
No, I don't have any instruction regarding that. I'm representing only defendant 1 in the tax suit.
No, you cannot say. It is a written statement filed by everybody.
Jointly.
Then,
But Your Honor, the contact with all the defendants
and
was,
you did not sign you had authorized the defendant number 2. Why the defendant number 2 has not filed that application?
no knowledge regarding.
You did not sign the you only signed the written
Okay.
statement, but you had authorized the defendant number 2 for yourself and to take steps on behalf of the case. And as such, the defendant number 2 filed a year. Now, the defendant number 2 has not filed that application.
Okay.
If the defendant number 2 has not filed that application, then in that case, would it be proper? Why should we revert it back? Because the written statement has been filed by defendant number 1 to 7,
Jointly.
isn't it?
Yes, sir.
And the written statement was filed on your behalf by the defendant number 2. So that means the defendant number 2 must have been in here with everybody because she categorically says that I am the defendant number 2 in the and taking steps in the suit. And she does not come and your allegation is that the defendant number 2 did not have anything. You say about Khogan Sharma, whereas the written statement has been filed by defendant number 2. So your case is absolutely false. Kindly see page 60. Mr. Doctor, what do you say?
Your Lordship may see at page 186. Defendant number 2 have been specifically authorized by this 4 persons. At page 186.
Then? No, not only that, it is on the
And
page
the-
60.
Written statement also, Your Lordship has seen.
Then you should have said, therefore, your case should have been the defendant number 2, I have no business out there. Defendant number 2 did not, because your entire case is false. You do one thing.
Date to satisfy this court.
Huh?
A date may be given to satisfy this court before the next date of the lower court.
What?
A date may be allowed to satisfy this honorable court. I'll come with proper instructions also.
With me?
Yes.
You have given 5 minutes, that is enough. No more time.
My lord,
You
Your
do
Lordship-
one thing. You participate in the hearing. That's it. He can participate in the hearing.
Yes.
Arguments, you can participate.
Right.
Yes.
My lord, one part of the thing, my lord, I want to highlight. After taking the stay order from this honorable court, they started construction there and they have completed the construction. There was an inquiry. My lord, your lordship will find we have an accident. at page 193, my lord. I'm just trying to show their conduct. Okay, one. Commissioner report. 193.
No, was there any injunction order?
Injunction is there on the status quo order passed by this honorable court in a writ petition. Because what they did,
No,
Yes.
here, what order has been passed?
my lord, there is an order by this honorable court to make an inquiry. And in terms of that inquiry was made, and this is the.
No,
report.
no. You see, we are directing here state. Further proceedings of title suit was only state.
State by this honorable court, the title suit was, but taking advantage of this order, they started construction.
That is not beyond my purview.
My lord, your lordship can say that the trial court may look into that also.
Why should I? I'm not going to say all this.
Because they have violated all the.
And that is not my lookout. You know what to do. If there is a violation of the status quo order, you should take appropriate steps.
The trial court can take into consideration of.
Trial court will know what to do. I am only concerned with this order. Lack of heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. S. Dr. the learned senior counsel assisted by so-and-so appearing on behalf of the respondents. Numbers?
All this.
Even how many plaintiffs were there?
Plaintiffs, my lord. Original, my lord, plaintiff one, after the death of the plaintiff, when the legal heirs came in, my lord.
Plaintiff was one, and these are all the legal
Legal
representatives.
heirs.
Okay. So you are appearing for them, no?
Yes.
All the rest.
Yes.
Post. The present application has been filed challenging the order dated 24/6/2024, passed in Mizze case number 360/2024, arising out of title suit number 39/2012, whereby the application filed under order 9 rule 7 for setting aside the ex parte order and to recall the orders dated 21/11/2022 and 5/7/2023 was rejected. First, this court finds it relevant to take note of that the plaintiff who was the predecessor in interest of the present respondents had filed a suit being title suit number 39/2012 against various defendants, of which the defendant number 1 to 7 were the main defendants and defendant number 8 to 10 were the performer defendants. The record reveals that the defendant numbers 1 to 7 had jointly filed a written statement on 18th of August 2012. First, it is specific. It is very pertinent to take note of that in the written statement filed by the defendant numbers 1 to 7, the verification as well as the affidavit, which is required to be filed under Order 6 Rule 15, was done by the defendant number 2. And it was specifically mentioned in the affidavit filed by the defendant number 2 in support of the written statement that she had been authorized to take steps in the suit for self and for on behalf of the other defendants. First, the suit thereupon proceeded. First, and was at the stage and the suit thereupon proceeded. First, When the plaintiff adduced evidence, comma, the defendant did not take any steps for cross-examination of the plaintiff witnesses, and further, the defendant also, in spite of given opportunity, did not adduce any evidence. The suit was at the stage of passing of the judgment after the arguments when the application was filed by the petitioner, who was the defendant number 1 in the suit, alleging inter alia that the entire responsibility for the suit, for taking steps in the suit, was given to the defendant number 7, and the defendant number 7 was in touch with the counsel. However, after the defendant number 7 died, comma, there was no connection between the plaintiff, the petitioner, oblique the defendant number 1 with the counsel. And as such, the suit proceeded ex parte to the stage of arguments. Full stop. The said stand so taken by the defendant number 1 oblique the petitioner herein, on the face of it, appears to be incorrect, taking into account the very statement, taking into account that the defendant number 2 had categorically stated in the written statement that she was authorized to take steps on behalf of all the defendants. Full stop. It is further very important, it is further apposite herein to take note of that the defendant number 2 or any other defendants did not approach the court for the purpose of setting aside the ex parte proceedings continuing against the petitioner, against them. And it is only the petitioner who has approached this court. First, the reasons, therefore, so assigned in the application so filed by the petitioner before the learned trial court, therefore, does not appear to be good reason, good cause to permit the petitioner, oblique the defendant number 1, to relegate the suit to the date on which the plaintiff evidence was adduced, or plaintiff witnesses were to be cross-examined. First, under such circumstances, this court does not find any merit in the instant petition, for which the instant petition stands dismissed. This court further takes note of that the defendant herein, further takes note of that the defendant herein, the defendants, this court further takes note of that as per the settled principle of law, the defendants can appear on any date from the stage the suit is presently fixed. First, considering the above, comma, as the suit is fixed at the stage of arguments, comma, the defendants can very well participate in the arguments.
Fixed for judgment.
You know, and now it will be for argument. That person must have forgotten. And that judge may not have been there.
Judge is Bedford also.
And then you want that to judges to arguments. First, it is seen that by an order dated 18/9/2024, the further proceedings of title suit number 39/2012 pending before the court of so-and-so, Civil Judge Senior Division number 3, Kamrup Metro at Guwahati was stayed. The said proceeding stands, the said interim order stands vacated, and the parties are directed to appear before the learned trial court on 14/7/2025 for further proceedings of the suit.
Much of
What is this IA business?
that, my lord, we filed an application for, my lord, they have violated the court's order. Then take care of that. Oblige.
So and so submits that some time may be granted to file the proposed substantial questions of law. Where? Oh, it has been filed. The learned counsel submits that she may be given some time in the matter, list the matter after vacations. Yes,
My lord,
Mr.
appeal.
What is the
Yes,
affair with
against
this?
the rejection of the injunction by,
Huh?
appeal against the rejection of the injunction order, injunction by.
Your injunction has been diffused.
Yes, sir. At page 8, my lord, impugned order,
Page?
page 8.
In view of the result, design is not fixed by the grant of England, therefore, here violation. Okay, what is your injunction you are asking for?
Only for that, he did not change the nature and character of the suit.
Huh?
Nature and character of the suit.
That on the contrary,
For
from
not
the
changing
suit length along
the
with the
nature and
defendant
character of
standing there
suit.
following
Nothing
the
more.
of the appeal in view of the family agreement with the You are not in possession.
I'm not position, my lord, but
Then?
only nature and character. And for this purpose, my lord.
What
may I
right do
take-
you have over the land?
Yes, because actually the land belongs to me, my,
Huh?
and that's why my
So
lord.
for
the suit was filed.
declaration is valued at rupees 1 crore. For ejectment
lord,
at
your
rupees
lordship will come.
1,000.
To page 20, my lord. My praise very.
No,
limited.
first and foremost, Mr. Khan. You are asking what suit are you filing?
I have filed this suit for declaration of right.
Then why you have not paid the court fee of rupees 11,000? Why haven't you paid the court fee of rupees 11,000?
Possibly at the-
No, you have paid 22 rupees. What is this? The trial courts, I think this is a fit case where I think I should pass appropriate directions.
My lord,
There is a
I would-
wrong thing which is going on before the trial court. That day also I found out. You are filing a suit for declaration along with permanent injunction.
Yes,
It's a suit based on declaration with consequential relief with coming under
Yes.
7(4)(c).
Good.
So therefore, when you are valuing the suit at rupees 1 crore and paying a court fee of rupees 22, does not
I have to pay
pay that.
whatever the court fee.
Pay that first, then pay, then we'll consider. This is an
My-
insufficiently,
even though
nothing.
Your
My
lordship
goodness.
may
And
record my
see,
undertaking. that
And therefore, you see, what is this? This is another suit, a retail statement come counterclaiming. Look here,
accounting
he has paid 11,000.
11.
Then why should we hear a person who has not paid?
My lord,
No, 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 no. I think this is a fit case for
my lord,
dismissal right away.
my lord, I am giving the undertaking to this
You
honorable.
pay
court.
that first, you pay, then we'll consider this type of
My
case.
lord, otherwise the matter would be delayed.
Not a matter will, nothing is going to, apparently it shows it is will a deficit
Hey.
court fee.
So for that aspect is concerned, I am ready to pay.
Pay that. We'll consider it after you
In
pay.
this honorable court or?
No, there.
There.
You
There
pay
I
that.
have to pay.
You pay first. It's a suit on the basis of order here. First, I'll pass that order. Then we'll consider of admitting. First, you pay that.
My
Yeah.
lord, if made as for payment, I undertake to pay. In the meantime, my lord, the status quo as on today may kindly.
What status quo? You don't have a case. First of all, you have not paid. Why should this court consider? On the other hand, they should be permitted to make any all constructions if they feel like, because they have paid 11,000. You cannot. What is this, Mr. Bhatti? Are you the counsel there? Are you the
Yes.
counsel? My goodness. Paying 22 rupees with the suit value that is 1 crore.
My lord, this is the practice going in the lower judiciary. And for that one, your lordship has to take the stern action.
I'm taking it right now. Right now, I'm saying this, that this cannot happen. That day, Mr. Samaria was also doing the same thing. He also has the habit of doing this thing. What is wrong with this court? It's a suit under 74C and you are paying that. He also paid that 22 rupees.
Bench, when we approach my lord, suppose if you want to pay, then more fees, they will know if your suit is only for declaration. Sometimes because they are also not clear, my lord.
No, they are clear. But what you do, I'm telling you, what you
Because
do,
guidelines-
you say that, no, you are valuing the
And we have also
declaration. For the purpose of declaration, you are valuing it separately again.
But Lordship, what if the bench are also not properly dealt with the subject matter, even some matters require suppose 50% court fee in terms of court fee, but they demand 100%. Because they are also not clear that which item required what kind of court fees. They just make a practice.
So for this, let me start.
Yes, my lord, your lordship may.
Chalo, first,
I
let me start
appreciate-
it with this only. That this is a case where
Yes.
there is a deficit and as such, this court should not exercise jurisdiction and the trial court was justified in rejecting the injunction.
I appreciate, my lord. But so far.
Laho. It is seen from the from a perusal of the plaint that a suit has been valued at rupees 1 crore. And the suit is for declaration with
My lord, I have.
consequential
paid-
relief. You have not paid, the counterclaimant has paid.
No, my lord.
Kindly come to page,
Myself has paid at page 20.
kindly come to page 14.
My lord, page 26.
You are the plaintiff?
Yes, I am the.
Kindly come to page 12.
Page 12.
Is your plaint? And kindly come to page 14. Yes. You've seen that the suit is for declaration with consequential reliefs which have been sought for. And on the basis thereof, the provisions of section 7(4) bracket C, 7 bracket small Roman 4, Roman C, small c, would be applicable
Of the court.
of the Court Fees Act 1870. That means that the court fee had to be paid of the ad valorem of the valuation of the suit. However, in the instant case, it is seen that in the suit, the court fee was paid of only rupees 22,000, 22 rupees, which apparently was not what is the actual court fee. Mr. O.P. Bhatti submits that he would pay the court fee before the learned trial court. within a week. Upon payment of the said court fee before the learned trial court. Now, this court grants the liberty to the petitioner, appellant, to pay the court fee before the learned trial court within 7 days from today. And thereupon, on production of the said acknowledgement from the learned court below, from the office of the learned court below, comma, the matter be listed again on 27th of June
Oh, my lord, 27th of June, I am leaving for Rajasthan.
after vacation.
Not, my lord, before vacation. On Monday, my lord, in the meantime, I will.
On 20, I've given you 7 days. Submits that he will deposit the court fee on by 28th of June 20
Let it be listed on.
and list the matter on 23rd of June.
But for that one, I have no, this, my lord, but this practice is going on. In
Correct.
Robert British.
This
And
practice
that has
needs,
to be stopped.
this practice has to be done
That has
something.
to be stopped.
I have to. In one judgment, I have made it out here. In the what was happening, there were 50 petitioners, only 50 rupees is paid. I passed a specific direction to that effect, and now they insist 50 petitioners, 50. Everybody has to pay 51 rupees, 60 rupees.
Does in my,
Eh?
does in my case.
It started with him.
But
Chalo. Yes, what is this, Mr. L. K. Bora?
Party. Actually, what
My lord, only the formal petition is yet to be filed because parties have not assembled in Guwahati.
drafted?
You have filed it.
No, yet to be filed.
You want to withdraw this?
No, the respondent is, he's the plaintiff, I am the respondent.
No, no. The suit I will withdraw.
You see, there's a stay here.
Yes.
So the stay has to be vacated. Then only you can file. So the parties have amicably resolved the dispute. So you want to withdraw this petition so that you can file appropriate application before that court, isn't it?
Caption may date fixed.
For what? I'll fix a date, but observation, no.
It's already fixed on 2nd July. my lord.
Draft has prepared, my lord.
I can't help you anything else. Whether you file or not, that is not between me and you. Mr. L. K. Bora, as well as Mr. B, the learned counsel for the petitioner, and Mr. B. Pathak, the learned counsel appearing on behalf of the respondent, submits that the matters have been amicably resolved between the parties before the learned parties in the suit. Under such circumstances, the learned counsel appearing on behalf of the petitioner submits that the petitioner would not like to press the instant petition. Accordingly, the instant petition stands closed on withdrawal, the interim order passed on 19/2/2025, whereby title suit number 777/2023, pending before the court of the learned civil judge, senior division number 3, Kamrup Metro at Guwahati was stayed, is hereby vacated. Full. As the parties are duly represented, they are directed to appear before the learned trial court on 2nd of July 2025 for further proceedings of title suit number 777/2023.
Keep there.
Must be.
Yes, what is this?
Been filed by the insurance company.
Huh?
This is an appeal filed by the insurance company.
For what?
That's it. It has been filed by the private.
Why are you filing it?
That's it.
Why are you filing it?
Fair Lordship. It is a case of murder.
Then?
And Lordship, it was subsequently converted to the Lordship, it is motor accident case.
Then
So appeal,
murder how?
with a iron rod. With a iron rod, his nephew of the deceased filed FIR before the police station.
Who filed the FIR?
The deceased.
That it was by way of an iron rod. Later on, it was found that the iron rod was sticking to a car. Huh? how did they do it?
And he was going in a scooty and it was knocked down by a other vehicle, not by the iron rod.
There is no iron rod. And what does the postmortem say? No, postmortem will show that. Was it because of the iron rod or it was of an impact?
By shear is necessary.
You should know. That is their ground, I think we should dismiss it.
To file this evidence also, they have reduced 3 evidences, we have also reduced 3 evidences. And WS also, there is no such issue.
Where is the postmortem report?
Postmortem report is also, Lordship, there is nothing, plant injury, Lordship.
Huh?
Postmortem
No,
is
let
also-
us see the postmortem report. Yes, you are finance. We'll take up one matter after this.
Evidence is there also, Lord.
Where is the postmortem? That is the main crux.
No,
Mr.
Lordship,
K.K.
this
Bhatta, appearing on behalf of the appellant, submits that some time may be allowed so that he can go through the evidence in support of his ground of objection so taken in the instant appeal. List the matter of the vacation.
One date may come.
Huh?
One date may come, Lordship.
You will have a better judge after vacation.
No, Lordship. Lordship, I like you, Lordship.
No, you don't like me.
But yes,
We'll have it after, yeah. Because if I take it, it will dismiss.
no,
Because he has to come up with that postmortem. If that postmortem doesn't show, I'm not bothered with the what FIRs is. The postmortem report is the main crux. If it is by way of a sharp iron instrument or by hitting on by head by something, it will be apparent. Otherwise, if it is by a blunt force, then the question of it is an accident.
Lordship, police also examine.
Police, I also know, you also know.
Yes, Lordship.
Yes.
Lordship, why- Lordship.
Yes. Where is the guy? Now the High Court Counsel has gone for a search. Okay. Mr. Gogoi, here his case is that some amount,
Yes.
he is a casual worker or something, they have not paid some amount.
From May onwards, he's not receiving his minus fixed pay.
So
And
we
from
do
any-
one thing, we have it immediately after vacation
Hello.
on 17th of July.
Hello.
In the meantime, you get your instructions,
Sure.
both of you. Where is the other side?
That's
High
it.
Court? Both of you take the instructions so that we finish it off on that date.
Lordship.
Issue notice making it returnable on 17th of July 2025. Pusto, Mr. B. Gogoi appears and
Yes.
accepts notice on behalf of the respondent number 1, 3, and 6. You can take for 1 also.
Yes.
1, 3, and 6. Pusto, Mr. G. Busha, the learned standing counsel of the Guwahati High Court accepts notice on behalf of the respondent number 2, 4, and 5. The petitioner herein extra copies of the writ petition be served upon them during the course of the day. The petitioner herein, who is a casual employee, being aggrieved on account of the sudden stoppage of his salary since the month of May 2025, have approached this court by filing the present writ petition. Full stop. The learned counsel appearing on behalf of the petitioner submits that the petitioner continues to render his services. However, without any justifiable reasons, the petitioner's salary has been stopped. Full stop. The respondents herein, and more particularly, the respondent numbers 4 and 5 shall apprise this court as to why 3, 4, and 5 shall apprise this court as to why the petitioner's salary have been stopped. Full stop. Taking into account that it is a case where the petitioner's salary has been stopped, an attempt will be made to dispose of the writ petition on the next date, comma, the said respondents. Yeah. You get your instructions, we finish it.
No, so we say one also, because any proposal will have to be moved through one.
No, here, why it has been stopped? 1, 3, and 4. will look at you.
The-
Why it has been stopped,
only
that's all.
for that,
we know.
only one regulation issue is also there. madam.
We'll see.
Fine.
Regulation not, I won't grant it.
filed with the insurance company lawsuit, mainly on the ground that the driving license of the driver lawsuit who drove the vehicle at the time of accident. It was fake lawsuit. And
Fake?
fake.
How do you
That
know?
means, Lordship, the report says that after verification, Lordship, the driving license they have mentioned in the claim petition and accident information report, Lordship. That was verified and it was issued in the name of two other persons, Lordship, not in the name of the driver who drove the vehicle at the time of accident. That is Tapan Kumar, Lordship. We have taken this plea in the additional written statement also we have taken plea and.
And what did
we
the
have
court
proved it.
do?
Court says that it is, if we were to prove by detail, Lordship, may kindly see the paragraph.
Coming
11
to
and
the
12,
question, where is that? As regard
Paragraph-
driving license?
11, Lordship. Paragraph 11, page number 12.
Insurance established, intending to establish the alleged violation of the law. Appeal admitted. This is an appeal filed under section 173 of the Motor Vehicles Act 1973, 88, challenging the judgment and award dated 10/10/2023, passed in MACT case number 267/2015, whereby an amount of rupees 5,58,689, along with interest at the rate of 6% per annum, have been awarded from the date of filing of the claim petition, that is 16/2/2015. Full stop. The learned counsel appearing on behalf of the appellant submitted that the learned tribunal, that is the court, that is the learned member MACT number 1, Kamrup Metro at Guwahati, did not take into consideration, did not properly decide the issue as regards the driving license, as regards the defense taken by the appellant insurance company, that the driving license of the driver, driving
Motorcycle.
license of the driver who was driving the motorcycle bearing registration number AS 14D2972 was a fake driving license. So taking into account the said grounds of objection, this court admits the appeal. First, to call for the records, steps be taken upon respondents by way of Mr. Swen. So J. Sharma appears on behalf of the respondent number 1. So as regards the other respondents, steps be taken by way of registered as well as usual. First, respond number 2 and 3. First, I on divorce take or not. This is an application filed for stay of the judgment and award dated so and so. এইখানে লিখে দিব। This court have admitted the appeal by taking note of the ground of objection so taken. Full stop. From the appeal, from the ground of objection, it is apparent that there is no ground of objection taken challenging the quantum to which the appellant, the claimant is entitled to.
With indulgence, lordship. Because income that was not proved and taken, I leave up to your lordship.
Then we take that 8,000, it will be much
No,
more.
lordship, I leave
Don't
up to your
take that
lordship. Plus, I have mentioned.
on
I
the
have taken
quantum.
Down.
Have not challenged the year on quantum. No, though I have challenged the quantum, but in the opinion of this court, that the said ground of objection has no legs to stand. Considering the above, this court stays the judgment and decree award dated so and so, subject to deposit of rupees 5,58,689, along with interest at the rate of 6% per annum from the date of filing of the claim petition dated 16/2/2015 till date, within 6 weeks before the registry of this court. Full stop. The registry, the claimant number 1 shall be at liberty to file an application for release of the said amount, and the registry shall হেখিনি লিখি দিব। ঠিক আছে। This court observes and directs that in the circumstance the appellant is successful in the instant appeal, appropriate directions would be passed for recovery of the said amount from the owner of the vehicle. I extend this.
Obliged, lordship.
Appeal memo may be furnished, my lord. Copy
Eh?
of the appeal memo may be furnished, my lord.
Oh, please.
Obliged.
এইটো লিখি দিব দেই, copy of the, yeah.
Obliged.
Yes, Mr. Biswas.
I filed an MSCD case because my wife was a pillion rider. But learned court below has rejected my, in spite of the fact that there is a policy page 32 is my policy. It was not accepted that side, it is not, pillion rider is not covered. But there is a IRDD, the circular manner, that is in page 60, page 56, liability of the insurance companies in respect of the occupant of a private car and pillion rider in two-wheeler under standard motor package policy, also called comprehensive policy. And on the basis
No,
of
you are asking for what?
my compensation,
No, there is some compensation awarded.
no, nothing, rejected.
You are challenging which one?
Similar case, another judge of the MSCT court of the same place has granted the compensation. That I have understand. Referring the two
Where is the
judgments,
impugned judgment?
yes, that is in Annexure 7, impugned judgment.
Page?
Yes, yes.
Measure seven gives some 9,77,000.
That is a case, another case, my lord, and a similar case, my lord, where the court has granted bail as I'm sorry, compensation.
No,
But the
which
new
is
charge who has
which
taken
is
over
the
my case.
impugned order?
Yes. Page 51, my lord.
What do you say about the judgment which have been referred to by the Learned Trial Court?
My lord, for the trial court is saying that the fill and rider is not third party. But my lord, my policy, I want to show you, lord, my lord, page 32.
Yes.
So, my, as per the IRD, my lord, page 56, liability of insurance company in respect of the occupants of a private car and pillion rider in two-wheelers under the standard motor package policy is also comprehensible.
What is the insurance policy taken?
Here it is, my lord, motor insurance two-wheeler policy bundle. It may be treated as standard motor package policy.
Kindly come to liability premiums,
Yes,
page 32.
yes, sir.
Personal accident cover for unnamed person of rupees 10 lakhs
Yes,
each for one person.
yes, I am 1%.
So this being so, wouldn't it be would it come under the Motor Vehicles Act or should it be before the ombudsman?
Motor Vehicles Act.
How? It will come up before the ombudsman or the insurance policy, before the before the, what do you call the, what do you name?
Whether I am covered under 164 the Motor Vehicles Act, my lord, notwithstanding anything containing this act or any law kind being forced, instrument having the force of law, the owner of the motor vehicle or the authorized insurer shall be liable to pay in case of death of the grievous hurt due to any accident arising out of the use of the motor vehicle, a compensation of a sum of 5 lakhs in case of death or two of the half lakhs rupees in case of the grievous hurt and legal years. In any claim, the compensation under subsection 1, claimant shall not be required to plead, establish the death of a grievous.
You are reading something which is there, which came into effect only from 1/4/2022.
Yes, yes.
Accident happened in 2021.
Yes, it is not.
So that would not apply. But be that as it may, the question therefore is, would it be before the Motor Accidents Claims Tribunal or should it be? Because taking into account that this is an agreement.
Yes, agreement, definitely.
So therefore, you will be entitled in terms with this PA cover.
Yes, personal accident.
So therefore, you have to apply before the ombudsman. You may not be getting, because you are not a third party.
I'm not third party, that is the court
So
finding.
therefore, being a third party, you would not get it. You have to therefore go to the insurance company, claim this amount
Before the
on the
ombudsman.
basis of the premium paid of rupees 350.
If that's so much right, pay before you are.
Similar type of case I have taken into account your case earlier, remember?
Yes, yes,
Because here there is a premium paid
yes.
for a pillion of rupees 350. So therefore, you will be entitled to claim from HDFC in any other proceedings, not before the Motor Accidents Claims Tribunal.
I'll approach her. If the lordship
You
will-
have a look, I think this is it, because one matter I have already dealt with in your matter, remember?
I have, now I have approached the insurance company.
The same thing, similar thing which had happened, that there was an insurance policy out there. Mr. Kolita, Mr. Soikia, na? Kolita. Mr. Kolita, isn't it? If he has already an insurance policy, that insurance policy includes personal cover insurance, personal insurance. You see, PA cover for owner 15 lakhs, 375.
Yes,
PA cover for unnamed person of rupees 10 lakhs each for one person, rupees 350. So therefore, he would not come within the ambit of the Motor Vehicles Act. Huh? Insurance company. Because he has to apply before the insurance company, not before the Motor Accidents Claims Tribunal. And it will be a claim which has to be made. If he doesn't do, it has to be by way of a suit. This is how it has to be done. The best option is for you to go to the insurance, first insurance company and then to the insurance ombudsman. Isn't it? We dispose it. Heard Mr. S.C. Biswas, the learned counsel, appearing on behalf of the appellant. Appellants, no?
yes, ma'am.
Appellants. This is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment dated 5/4/2025 passed in MSc death case number 24/2023, whereby the Learned Motor Accidents Claims Tribunal, Sirang Kazalgaon, had dismissed the same claim proceedings on the ground that the deceased, who was a pillion rider, would not get compensation, would not be entitled to compensation. Pusto. It is seen that the Learned Trial Court Tribunal had relied upon the judgment of the Supreme Court in the case of Oriental Insurance Co. Limited versus Sudhakaran KV, reported in 2024 for Supreme 329. Pusto. This court, having taken into account the materials on record and the facts, is of the opinion that the Learned Trial Tribunal was justified in rejecting the said claim proceedings. Pusto. Accordingly, this court do not find any ground to interfere with the said judgment and award order, judgment dated 5/4/2025. Pusto. Before parting with the record, this court, however, observes, taking into account the insurance policy, that insurance policy issued by the appellant, issued by the HDFC Argo General Insurance Limited in respect to the motorcycle bearing registration number,
Registration number.
bearing
AS
AS 26D 5329, that personal accident cover have been taken for both the owner as well as the unnamed person, and due premium have been paid. First, considering the above, the appellant's hearing would be within the, if so advised, would be advised, can approach the HDFC Argo General Insurance Company Limited seeking compensation in terms with the personal accident cover so taken. First, the period during which the proceedings before the claims tribunal has been pending till date be excluded while applying for such claims. Yes.
This is an appeal for enhancement, my lord. Because the medical bill, which is worth about 9 lakhs, has not been considered, only 3 lakhs has been given. That is the one of the grounds. Because your lordship will come to the page 32 now. Paragraph 19, my. Exhibit 9 and 91 are all the medical bills,
So these exhibit 9 to 991
are all medical bills, my lord.
for how much?
For 9 lakhs something, my lord.
What 9 lakhs?
9 lakh 20,000.
However, he gave only 3 lakh
Yes,
86.
that reason has not been given. Why?
There is an appeal filed under section so and so, challenging the judgment and award dated so and so, passed in MSc case number so and so, where an amount of rupees 4,46,670 have been awarded along with interest at the rate of 7.5% per annum from the date of filing of the case till realization. The instant appeal has been filed on the ground that from a peruse that the claimant have claimed an amount of rupees 9,20,000, and in that regard submitted due evidence in terms with exhibit 9(1) to 991. However, without assigning any reasons, the learned tribunal have reduced it to rupees 3,86,656. Full stop. Taking into account the said ground of objection, the instant appeal is admitted, call for the record steps be taken by way of registered as well as. Why?
Fixed on Friday. Also, I have not brought the entire file. I missed to carry the file also, entire file.
Okay, after vacation.
Friday next, my lordship.
What? This Friday not. We are in dirt of time.
Next
After
week
vacation.
also.
After vacation. At the request of Mr. T. Golter, the matter stands adjourned to be listed after vacation.
But
For examining matter, somehow I missed the item in the cause list matter.
Hello, we vacate the order.
But can it be taken up tomorrow, my lord?
No, no.
This was with regard to my lord an amendment, my lord, amendment petition, which was rejected. This, in the body of the plain, my lord, the schedule was mentioned, but in the subsequently, my lord, in the schedule part, the schedule A1 was not mentioned, and that prayer was rejected.
Was the stage?
Stage by lord, evidence is yet to start, man. PWs are yet to examine. They have not filed their evidence on anything.
What is the amendment you sought for?
Amendment, my lord, in the schedule part, my lord, schedule A was missing, my lord. That was, we, my lord, missed to
Huh?
incorporate the schedule A1. In the body of the plain, my lord, we mentioned about schedule A1, but in the, my lord, schedule part, A1 was not, A1 was missing, my lord. Only that much.
Why didn't you file it earlier?
My lord, at the time of filing of evidence on affidavit, that was brought into the notice, my lord, that the schedule was missing.
So now the suit will again go back to that stage, 2014 suit.
Yes.
Okay, 30,000
My lord,
cost.
because of some, my lord, pecuniary jurisdiction issues, my lord, that's why, my lord, the suit revolved from one court to the other, my lord, that's why it was delayed, my lord.
Okay, now we make it 50. Cost of 50,000.
But
We'll allow it subject to cost of. There is a counterclaim also. Oh. Now, what is the relief you are seeking by way of this?
Right?
Now you want a partition.
Yes,
Earlier, your case was not for partition.
was fine.
With a decree for partition of the amongst the, yeah, okay. Leho. Heard Mr. S. Das, the learned counsel appearing on behalf of the petitioner. None has appeared on behalf of the respondent in spite of service being affected upon
That's the-
the learned counsel appearing upon the respondents. The petitioner herein have assailed the order dated. Petitioner, petitioners.
Please, Sanar, ma'am. Kosik.
Petitioners herein have assailed the order dated 24/6/2019 passed in Ms. case number 154/2014. It has been stayed from then.
No, man. There was no stay, man.
Then I granted the
Yes, yes,
stay.
yes.
Now, what is the stage?
There is, my lord, filing of evidence on affidavit. Now it was fixed for appearance subsequently, my lord, because the suit was transferred from the Court of Civil Senior Division.
You have enclosed that, na?
Yes, yes.
Okay. The order dated 24/6/2019 passed in Ms. case number 154/2018 arising out of title suit number 11/2014, whereby the learned court of the civil judge Kamrup Amingaon had rejected the petition application filed under Order 6 Rule 17 of the code. It has been brought to the attention of this court that the learned counsel appearing on behalf of the petitioner has drawn the attention of this court to the application filed under Order 6 Rule 17. The learned counsel further submitted that on account of the inadvertence of the earlier counsel in not inserting the schedule A1 to the plaint, the issues which arises for consideration before the suit cannot be properly adjudicated. And it is under such circumstances, at the time of preparation of the evidence on affidavit of the plaintiffs, the newly engaged counsels had advised for filing an application under Order 6 Rule 17, seeking amendment of the plaint. The learned counsel further drawing the attention of the contents of the application under Order 6 Rule 17 submitted that from a perusal of the said petition application itself, it would show that the amendments which have been sought for would not change the nature and character of the suit. He therefore submitted that the amendments ought to have been allowed, taking into account that it was on an inadvertence of the learned counsel who was earlier representing the plaintiffs, the schedule A1 was not inserted, and immediately after engaging the newly engaged counsels upon the death of the earlier counsel, this aspect came to light. He therefore submitted that the learned trial court ought not to have rejected it merely on the ground of there being no due diligence, inasmuch as the due diligence was properly explained in paragraph number 2 of the said application. First, this court have duly considered the submission and have also perused the said application by which amendment was sought for. The reasons so assigned by the learned trial court in rejecting the said application is only on the ground that the trial has commenced and there was no due diligence. This aspect appears to be not proper. The approach so adopted by the learned trial court appears to be not proper, taking into account that reading of paragraph number 2 of the said application, it is seen that the plaintiffs of the petitioners have duly mentioned as to how the inadvertence of not inserting the schedule A1 to the plaintiff was discovered, and immediately thereupon the application being filed. Considering that the amendment so sought for is necessary for deciding the that the word you use the dispute.
Rajan ji,
Therefore, determining the real question in controversy between the parties, this court is of the opinion that that the said amendment application is required to be allowed. Full stop. This court further finds it relevant to take note of that the suit was filed in the year 2014 and the amendment application was filed in the year 2018. And in that process, the said suit proceedings and 18, first, it is further pertinent to take note of that the suit had proceeded to the stage of evidence, wherein, and evidence, on account of the inadvertence on the part of the plaintiff for not inserting the schedule A1, the defendant have suffered, the defendants now would have to endure the defendants would now again have to file a fresh written statement. First, under such circumstances, this court is of the opinion that this harassment so caused to the defendant can be compensated by imposing reasonable cost upon the petitioner, the plaintiff. Accordingly, the instant petition stands disposed of with the following observations and directions. First, the Ms. J case number 154/2018, so filed seeking amendment of the plaint is allowed. Number two, the plaintiff oblique the petitioners are given the liberty to file the amended plaint within amended plaint before the learned trial court by Ajikitari by 9th of July 2025. First, it is observed that if the amended plaint is not filed by the said date on or before the next said date, the provisions of Order 6, Rule 18 shall apply. Number three, this court further takes note of that presently the suit being title suit number with the suit number 11/2014 have been renumbered as title suit number 82/2024 and is transferred to the court of the learned civil judge, junior division, Kamrup, Amingaon. Full stop. The parties are directed to appear before the learned trial court on the said date on 9/7/2025. Full stop. Next. This court further imposes a cost of rupees 30,000 upon the petitioner. Full stop. The said amount cost of 30,000 which has to be deposited by the petitioner at the time of submission of the amended plaint. Full stop. It is observed that the depositing of the said amount of rupees 30,000 before the learned trial court shall be a condition precedent for acceptance of the amended plaint. Full stop. Next. The defendant in the suit would be at liberty to file appropriate application before the learned trial court for release of the said amount, and the learned trial court shall pass appropriate orders. Okay, 35,000 good.
Valuable.
Mr. Lal, your matter is after some time. Put it down. Yes, RSA. Against the joint decree passed in the suit as well as single second appeal has been filed. It is, however, relevant to take note the court fees of. Yes, what is this?
Paid it.
You paid? Okay, now submit. You have urgency in the matter? You have urgency in the matter? If you have urgency, do it. If you don't have urgency, after vacation, you may get a good judge. But from the nature of the orders passed from 2023, it appears that you have been delaying the appeal. Tell me, what is your ground? Substantial question of law? Page 9. Huh?
Amended memo filed.
Where? Page?
Filed on 22/4/2025.
Amended memo.
Page 79.
Page 79. Whether in view of the findings of the learned courts below that the plaintiff is in possession of the suit lands in remand under an invalid agreement, the predecessor here being the minor of that time, the learned below were justified in holding that plaintiff is in permissive possession of the suit land, the permission having been granted by the predecessor in the interest of the defendants, he being minor. Whether in view of the findings of the learned court below that the plaintiff is in possession of the suit land under an invalid agreement, having continued peacefully since 19 which is prima facie adverse to the true honor, the learned traveler was justified in that they never claimed right. You are a plaintiff or defendant?
Thank you.
Okay. Let us see your claim.
For confirmation of tenancy right and permanent injunction.
Huh? And the substantial questions of law are on adverse possession. Plaintiff is a permanent resident under the jurisdiction of your father so and so. Prior to the Iman stayed as a tenant for many years in the house of so and so along with his Iman. Later on, so and so demolished the house. Started constructing a residence. His father repeated the residence. Thereafter, his father repeated his requested the predecessor of the defendant. Where is the land?
Land is, 3 cutters southern lesson below.
Where is the land?
Land is at Nalbari district, Tihu town.
Town. Temporarily settled area doesn't come.
Its method in the year 1972. And I remained in the possession of the.
Was there any counterclaim filed?
File. They have filed counterclaim. In the written statement counterclaim, they have taken the play that that this defendant's father was a minor at the time of in the year 1972. Therefore, he cannot enter into a tenancy agreement. And he was my father was a permissive possessor since 1972. Both the courts will have come to a finding that my father was a minor, or my dependent's father was a minor in the year 1972. Therefore, he cannot enter into any agreement under the contract act. Both the courts will have come to a finding that since 1970.
So whatever agreement you were, the question is, are you paying rent? Did your father pay any rent?
For 3 years, I have paid.
Thereafter?
Thereafter, I did not pay.
Then what is your case? What is your defense?
I filed the suit for confirmation of a tenancy right. But
So you are not a tenant.
They have taken the.
Forget about them. Your case. What is your case?
My case is, my feeling that I'm a 10 and I'm a 10.
Then where is the question of adverse comes?
Since the, since both the courts come to a finding that my, his defendant's father was a minor, he cannot enter into any agreement, so-called tenancy agreement. If he was minor at that time, how can he be consented my father to enter into this land as a permissive occupant? As minor consent is no consent. Then my position since 1972 to 2014, what is my position? I am a trespasser. I'm a trespasser. And I remained in that position from since long.
Is it your case that you are a trespasser? Now
I'm-
forget about them. I'm asking you, is it your case that you are a trespasser? No case. You have not been able to execute.
We instruct them to file execution.
Why?
Execution case, we have instructed, but the present position,
Execution case should have been filed. The plaintiff should be thrown out. Chalo, we dismiss. Yes, from yesterday onwards, I've raised my rate of cost from 10,000 to 11,000 to 22,000. Dismissed with cost of 22,000. Eh? No vacation. This is finished today. I gave you a chance. You should have immediately grabbed that chance. But today I can't help you. Lego, it's a short judgment. Art Miss So-and-so, the learned counsel appearing on behalf of the appellant and Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. G. Bharadwaj, appearing on behalf of the he appears for appellants and she appears for the principal principal respondents. Even all,
yes,
even the performer also
yes.
appears on behalf of all the respondents. First, the appeal, the present appeal has been filed. Under section 100 of the Code of Civil Procedure, challenging the judgment and decree dated dated 14/12/2022, passed in title appeal number, title appeal number 1/2008, whereby the judgment and decree
1 of 2018,
huh?
title appeal number.
1/2018, whereby the judgment and decree dated 31/3/2018, passed in title suit number 13/2014, was affirmed. Full stop. The learned counsel appearing on behalf of the appellant have drawn the attention of this court that have proposed before this court two questions of law, which, as per her, can be framed as substantial questions of law involved in the instant appeal. The two questions of law so proposed reads as under page 79 note. This appeal is being presently taken up at the stage of Order 41, Rule 11, to ascertain as to whether any substantial question of law can be formulated in terms with section 100 bracket 4 of the code. Full stop. For the purpose of deciding the appeal, for the purpose of deciding the said aspect, this court briefly would like to take note of the brief facts which led to the filing of the instant appeal. The materials on record show that the plaintiff who is the predecessor in interest of the present appellants, claimed to be a tenant of in the house of one Rajan Pathak since 1972. Full stop. The said Rajan Pathak it was averred that the plaintiff's father was asked to vacate the place. And under such circumstances, the plaintiff's father approached the predecessor in interest of the principal defendant, namely one Dharmeshwar Das Sharma, brackets since deceased, to give him shelter temporarily. And accordingly, the father of the plaintiff was allowed to stay in the suit land by constructing a house on the house, full stop, on the basis of an oral agreement, on a house on the basis of an oral agreement by paying a nominal rent of rupees 120 per year. Full stop. Huh? The plaintiff's father thereupon started to reside in the suit land with his family, and a holding number was issued in respect to the property constructed by the plaintiff's father, being number 357 by the Tihu Town Committee. After 3 years, late Dharmeshwar Sharma stopped taking rent from the plaintiff's father and allowed him to stay without paying rent. In 1990, the father of the plaintiff expired, and the plaintiff and his family continued to reside in the suit land. However, after the death of late Dharmeshwar Sharma, Kolita, Sharma, the defendants threatened the plaintiff and asked them to vacate. It is under such circumstances the plaintiff instituted the suit. Seeking declaration seeking a decree for permanent possession as per tenancy right in favor of the plaintiff in respect to the scheduled land, as well as for permanent injunction. The defendants filed a written statement cum counterclaim, wherein various pleas were taken on the maintainability of the suit. The defendants denied the existence of the tenancy agreement between the predecessor of the defendant number 1 to 4 and the father of the plaintiff. The defendants also stated that the predecessor of the defendant number 1 to 4 was not the sole owner and he was a minor in the year 1972. The defendants contended that the predecessor of the plaintiff was permitted to stay at the land temporarily, and the defendants politely asked the plaintiff to vacate the suit land, but in spite of the plaintiff's tried to construct pakka latrine over the suit land, so the defendants demanded the plaintiff to vacate the suit land, and therefore filed a counterclaim seeking declaration of right title and interest and for eviction of the plaintiff. On the basis of the pleadings, as many as 9 issues were framed, which reads as under, which are reproduced herein under. The learned trial court, on behalf of the plaintiff, 4 witnesses were examined and 12 documents were exhibited. On behalf of the defendant, 4 witnesses also were examined and 5 documents were exhibited. The learned trial court, after taking into account the evidence on record, dismissed the suit and decreed the counterclaim. Being aggrieved, an appeal was preferred by the appellants herein, which was registered and numbered as title appeal number 1/2018. The learned first appellate court, after taking into account the grounds of objection taken in the appeal, the pleadings of the before the learned trial court, the issues so framed, and after issues so framed, semicolon, the submissions so made by the learned counsels appearing on behalf of the parties, decided the appeal issue-wise and dismissed the said appeal. It is under such circumstances that the present application has been filed, present appeal has been filed. In the backdrop of the above, dismissed the appeal by the judgment and decree dated 14/12/2022. In the backdrop of the above, let this court now take into account as to whether the proposed questions of law by the learned counsel appearing on behalf of the appellant can at all be formulated as substantial questions of law in terms with section 100(4) of the code. A perusal of the proposed questions of law indicate that what plea the appellants now chooses to take is a plea of adverse possession. In the opinion of this court, the question of taking a plea for adverse possession at the stage of, more particularly at the stage of second appeal, cannot be permitted. Further to that, the pleadings on record categorically show that the plaintiffs, as well the original plaintiff as well as the plaintiff categorically admitted did not at any stage allege that the plaintiff's possession was adverse to the true owner, to the defendants. First, considering the above, the said two substantial questions of law, the proposed questions of law cannot be formulated as substantial questions of law in the instant appeal. First, this court have further perused the judgment passed by the learned First Appellate Court, and therefrom, it does not appear that there is any other substantial question of law which can be formulated. First, as in the instant appeal, there cannot be no substantial question of law that can be formulated, the instant appeal cannot be proceeded with, for which the appeal stands dismissed. Taking into account that the appeal is being dismissed at the stage of Order 41, Rule 11, this court is not inclined to impose any costs. It is further seen that the LCR have been called for by this court earlier, by the learned coordinate bench of this court earlier. The said LCR be returned forthwith by the registrar.
So your lordship had earlier heard this matter, in RSA, regular second appeal matter. The moot question involved in this appeal is that whether long possession of one co-sharer will extinguish the right of the other co-sharers over ancestral land.
What?
Over ancestral land. Basically, the defendants are the sons and daughters of the first wife of the original Patak, and the plaintiffs are the sons, daughter, and second wife. So now the defendant had encroached some portion of land which fell into the share of the plaintiff. We filed a suit in the 2012. Thereafter, we came to know that there was an mutation entry in the year 1994. So the learned trial court thought that since there was a mutation, we did not have possession. So there is no question of dispossession in the year 2012. And only on that finding, my lord, the entire suit was dismissed.
Cases, you are plaintiff.
Plaintiffs.
Your case is?
Recovery.
That okay.
Yes.
Who is the owner of the land?
Owner, my lord, is the predecessor interest is the father. Father.
Father of the?
Plaintiffs.
And
the defendant.
Both?
Both same.
Father of the plaintiff and defendant is the owner of the land?
Yes.
Okay, A. Then,
as per my lord, Mohammedan law, they got certain plot of land. There was some kind of amicable settlement. So they got their share, we got our share. Now our case is that while we were away from the place, they encroached around 2 kathas of land in the 2012.
who? Defendant?
Defendants. So thereafter, we also came to know that there was a mutation entry. Mutation entry of the year 1994, wherein the name of the defendant number 1 was mutated over that suit land. Thereafter, we filed this suit. Now the lower court.
You filed the suit when?
2012.
So 1994 is the entry, you know it and you file it in 2012.
Yes, we came to know about that entry in the year 2012 only. Then, my lord, the learned court below came to a finding that since there is a mutation entry of the year 1994, there was no disposition in the year 2012. So they were in possession since 1994. So we do not have any cause of action.
So you made a false statement.
So that is the finding of the court below. my lord.
I am asking you also because you must have said that you were in possession
Yes,
and you were dispossessed in 2012.
yes.
So the trial court came to the trial court came to a finding that as there is a mutation entry of in the year 1994,
Yes.
and mutation means not only title, possession
Possession.
also. So therefore they were in possession.
Yes,
So the question of you being dispossessed
Yes.
in the year 2012 is foreign.
yes.
Then
Then, my lord, their case is that how they came into possession, the genesis of the possession, according to them, is that there was some kind of oral sale made by the other co-sharers in favor of the defendant number one, and also some kind of relinquishment, which they could not prove. Now our case is that even if we could not prove our disposition over that plot of land, Sut land, but our right over the entire Patta land will not get extinguished because one of the source of the possession is right of inheritance, my lord.
what is your claim in the suit?
Claim, my lord, joint right title interest over the entire Patta land, plus, my lord, right title interest of the plaintiff over that particular suit land, and recovery of possession from that plot of land.
How?
By
From
partition.
that land, how are you claiming?
Because there was some kind of amicable settlement, my lord.
But there is no amicable settlement. So therefore, you have to prove that you had an amicable settlement.
Yes,
Did you
but there
prove
was
it?
no partition.
So the amicable settlement is the partition.
So formal partition was not there.
What is that formal by writing?
Formal, my lord.
Oral partition can happen.
Yes,
So there was a amicable settlement is the oral partition.
yes,
You failed to prove.
yes.
So therefore, it's a finding of fact. So nothing means.
But Dr. will-
Dismiss.
Dr. will kindly come to the findings of the trial court, my lord.
No, no. We need not look into this.
Because, my lord,
Concurrent.
concurrent.
So finish. No case.
But at least also will kindly see the source of possession, my lord.
Huh?
Their claim, my lord, the claim of the defendants, how they got into the possession, my lord.
I'm not concerned. You failed to prove that.
Oh, but it's an ancestral land, my lord. It's by way of right of inheritance.
So
my lord. We
are
have-
you asking why you are asking that plot of land? You yourself say that you have amicably settled
Yes,
long time back.
Yes.
And then you were outside.
but my lord, even if we fail to prove our right over that particular plot of land, but our right over the entire Patta land will not become extinguished, my lord, because
Did you ask for partition?
yes,
Let's see your claim.
yes.
Where your partition, so
It is in, my lord, page number 301. The prayer portion.
is there counterclaim?
No counterclaim.
So you have substantial question of law. You have given three. Which one do you want? Today I'll be a bit lenient. Which one do you want?
My lord, 2 and 3,
One only.
Two.
No, only one. I have never framed in my lifetime two substantial questions. Only one.
the number 1 will do.
Only one.
Yes,
No more.
no.
Whether the learned courts below were correct in holding that the long possession of the Iman or Bayan had extinguished the title of the appellants over the Schedule 1 land, when the Schedule 1 land is a part of the ancestry belonging to the pair of late. Okay, where is that finding?
That finding, my lord, is at page number 60.
Huh?
60.
60.
Para number 20.
So, this is not the finding.
This is the overall finding.
This finding is that you failed to prove.
Yes.
Then, do you know why I asked amongst the three? So I'll only consider that one for your dismissal of the appeal. Now come up.
But-
Otherwise, I'll say you have waived. So only on that one I will now discuss.
Yes, sir. My only contention is
That is not the finding. You fail to prove.
No, but the court ought to have considered the title of the plaintiff over the other portion of the.
Now, the plaintiff has failed to prove that they have right title over the C1 land
Yes,
by way of amicable partition.
yes,
As such, they are not entitled to separation of the shares by way of creation of a separate dag and patta. Additionally, in the plaint, they have also claimed that they were amicably possessing their respective shares as per Islamic rules of succession. If that was the case, the plaintiff ought to have sought for partition of the entire ancestral property in view of Order 20, Rule 18. The plaintiffs have neither prayed for the said relief as a whole, nor have they proven the plea of adverse armiage. So entire case is on amicable partition.
yes.
Then you fail to
No,
prove that.
If the lordship will kindly see parallel.
Mr.
number D,
Mr. Das, your case which you are raising out here is on the question of that you now you want the entire thing.
Yes,
Go for the partition of the entire thing. Now you want to forget the amicable partition. But that is not the part, this is not your case.
so that was our case. If the lordship
Where is your
kindly-
case that
Prayer-
you
prayer
want the amicable partition of the
prayer-
entire land? No,
Prayer B, my lord. Prayer B,
no, 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 no.
that they have joint right title interest over the schedule C land, which is a part of schedule A land. That prayer ought to have been considered, my lord.
No, 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 no. Schedule C is of the plaintiff. Schedule C is only of the plaintiff.
Yes. Common right title interest,
The total land is what?
total, my lord, is schedule A.
Huh?
Schedule A.
So schedule A, you have not asked for that. You should have asked for the schedule A.
But that right, my lord, will remain.
Your basic case is that kindly give me schedule C
Yes,
because I have got it by way of amicable
Yes.
partition.
yes,
You never asked for that.
yes.
No. But go and file separate suit. Seeking partition, you can very well do.
But the right, overall right over this land, my lord, will not get extinguished, my lord.
This
by-
is not your
Yes,
case.
yes, I understand.
Your case. Therefore, how can it be a substantial question of law involved? Your substantial question of law number one says that as schedule C1 is an ancestral property. Now you yourself, your case is schedule A land have already been partitioned. And therefore the schedule 1C land, C1 land fell in my share. So therefore, the court should have held that I had the right, but that is not your case in your plain.
After partition, man.
So your partition means, first of all, the court did not accept as a finding of fact that there was a partition. Therefore, the appellate court categorically deals with that. If you had asked for schedule A land, it's a different thing. That is not your case. Now, what you are trying to bring by way of this substantial question of law is taking away or circumventing what has been held by both the courts. That you are never your case asking for schedule A.
Yes. But regarding amicable settlement.
Now, after not getting the schedule A, you are not, if you have asked for partition of schedule A, it's fantastic. But you are saying this schedule C, which was a part of schedule A, and say therefore, which now they are claiming, you are saying that I have a right in schedule 1 land. Very well, you may have a right, but you have to ask for partition of schedule A.
That will be there in the evidence, madam.
Then why you are only asking for only one portion?
No, that amicable settlement.
That is a
part
finding of fact.
Will be there in the evidence, madam.
That's
If
a
the
finding
lordship
of fact.
goes to the evidence, it will be there. Perhaps it might also be the case that there was misinterpretation or misappropriation of.
This
fact.
is a case directly coming under paragraph 15 of Santosan. Having not raised the issue before the trial court, in your plain, in the pleadings, findings of fact, nothing is there. So why should I?
I'll satisfy lordship, and I'll just place the evidence, madam.
Why should I look? No appreciation of evidence.
Misappropriation may also be illegal, madam. That can be looked into, madam.
What?
if the learned court below had misappreciated the evidence.
Misappreciation is not for this business.
Because,
purpose.
Manoj-
It's a finding of fact.
Because our case was there that there was amicable settlement, my lord, and on that basis,
Court
We-
case. Chalo. I've got hold of you, you don't want 2 and 3, we won't go to 2 and 3, with 1 we dismiss.
I'll satisfy lordship, my lord, and place the, my lord, evidence, my lord.
No, this is not your case, Bill. If you have asked for partition of Schedule A, I'll give you the liberty, go ahead. File another suit for partition of Schedule A. Mr. Das, it is a very clever gesture on him. Your basic case is Schedule A has been partitioned, Schedule C1 fell into my schedule. So kindly do the partition and give it to me.
Yes.
Now you want formally.
Yes.
A partition Schedule C1
Yes.
is mine, which the defendants are in possession from 1994 or by way of mutation they have got the Schedule 1. Now you don't ask for the partition of Schedule A land. So when you are losing everywhere, so therefore you go for a partition of the Schedule C1 land, because I have a right there also. And because of Schedule 1 land, I'll get a share. But without taking into account that Schedule A land has to be without a partition asking for the entire land, you cannot ask C1. This is your answer to your substantial proposed question. No. Facts are very clear. That is why this is the third time.
My lord, fix a date, my lord, I'll satisfy lordship on this one. Regarding our
am not
case on amicable settlement, my lord, and whether the court rightly considered that fact or not.
No, the question does not arise. Not satisfied. Chalo, after vacation, you may get a good judge. The council appearing on behalf of the appellant seeks for some time to list the matter to the petitions.
I think on the last occasion, though I was not there, the lordship had expressed to enter into the main merit of the, though there are some applications pending with regard to implement and of some of the dependents and cases. Definitely.
Who died?
Quite a few of them have expired.
Hmm?
And some objections have been raised by my learned colleague with regard to some technical defects which have been filed during the filing of this.
Who died?
Lordship, appellant number 1B,
1.
within bracket B.
Then
Then your lordship will find respondent number 1. And appellant number 3.
and appellant number
3.
When did these people die?
Appellant number 3.
1E.
1E, your lordship. There is a delay of some 640 days. The death certificate is 21/6/22.
Appellant number 1E died in 21/6/2022.
21/6/22.
Then
And
respond number 3, appellant number 3.
appellant number 3. Date of death is recorded on 14/4/2022. 2017.
And respond number one,
Respondent number 1.
Eight five nineteen.
8519.
85?
19, 2019.
Okay. Why you could not file these applications within time?
Due to some communication gap with the earlier council, that is what we have pleaded here. And because now we are the new sets of council, the earlier council, though was informed, it appears he did not take the steps. That is, we have pleaded in the application we have. filed.
So what steps have you taken against that?
That is, no steps against the earlier council.
Then
And the
merely by blaming the earlier council, you
know,
can
I-
do it.
think that there was some communication gap with regard to the appealants with the earlier set of council. But there is no such thing before the, as your lordship takes a stand with regard to before the appropriate authority, no steps have to be.
Then
Even number 3 was the person who used to communicate, was the link between the earlier council and the appellants, your lordship. But after his demise, there were the other appellants were not aware of the council as such. And later on, when they made a research and with the assistance of Mr.
who informed that the case is pending? If these people were not aware,
They made an inquiry, that is what we have pleaded, your lordship.
who made the inquiry?
The other appellants came.
How did they know they had to make an inquiry?
Because of the long tendency, they did not have any.
What is this long pendency? So they thought that the appeal was dismissed.
That, that, that is what is reflected in this application, your lordship.
Huh?
That,
How did they know that the appeal was pending?
they.
If they
if
had
your
no
lordship
communication
sees
with the
para five,
lawyer?
It is what have been stated. Para 5 of the application we filed. for
I'm not
signature.
concerned with the para 5. Have you not read your file?
Yes, that is what.
Then
I'm
I'm asking you a straightforward question. Why you are not
saying.
answering
They-
that?
Because of the long tendency, they came forward and made an inquiry in the High Court. And he wasn't,
How did he know that about that case?
there was a case they knew, but he did not know who was the counsel they were to approach. And who is to,
So are you saying that these appellants did not file a wakalatnama?
they filed the wakalatnama.
So they
Appealant
didn't
number-
know who was the counsel?
Appealant number 3 was their brother who had engaged this particular.
How can he engage? Are you not signing the wakalatnama?
It appears that he had brought the wakalatnama, signed wakalatnama, and
So
And
that
that-
means these people, these appellants did not engage him.
through the brother, they had engaged.
How
Personally-
is it through the brother it
personally,
can be
appears
engaged?
From that, that personally, that.
Are you saying that a person can execute a wakalatnama somewhere and that
is what
wakalatnama
is-
can be
that is what
used?
has transpired.
So you say that you don't have that ground to that effect. Okay, on that ground, we dismiss it.
That is the ground he had appeared when he had filed this application.
Cannot be the ground.
They had no knowledge of the council. and
How
appealant
can they say that they don't have the knowledge when they signed the wakalatnama?
was- That is the thing that their brother was looking after the case.
He may look after the case is a different aspect of the matter, but can he say, that means this appeal which has
Yes,
been
sir.
filed on the basis of what? This is not on affidavit.
It is a
This-
a second.
This
appeal.
is, yes, so it is on a certificate. So under such circumstance, this particular council was not authorized to file an appeal by these appellants.
Strength of the wakalat.
No, wakalatnama cannot happen because of the fact that they don't know who was the counsel.
That was there, that is,
So on the basis of the wakalatnama, they couldn't have been. So under such circumstance, these people did not give the wakalatnama to that person.
I Directly, they did not.
So
give
these appellants therefore did not know,
Personally, as.
did not authorize this council to file the appeal. And if they
Other
did
on that,
not
even
authorize him to file the appeal, meaning thereby these people have also not asked them. The grounds of objection or the appeal has been filed by that lawyer who have not been authorized.
Appellate number 3 here.
Appellant number 3 may know that lawyer, but if the other lawyers, the other counsel, they don't know, because the question of thinking that wakalatnama is what?
Authority power to represent the person.
So they don't know whom they have given the power. So if they don't know whom they have given the power, that means there was no authority on behalf of these appellants to file an appeal. And if this authority was not given, so these appellants cannot come before this court and say that, look here, that lawyer was of any mistake, because they didn't appoint him.
Like in the sense that they had no communication with the,
The question communication, they don't know whom they have engaged.
did not know about his.
So that is
name.
the reason I think we
They did
close.
not have the contact number.
So
nothing.
this appeal cannot be deemed that it has been filed by on behalf of them.
Because for the information, the brother was only looking after.
IAS in instruction.
There are 4 hours.
No, the earlier ones.
That your lordship, there is a stay of application.
Your suit has been dismissed.
No, suit was allowed.
Suit was allowed.
The appeal was dismissed. The suit was preferred by them.
Now, how can you say that this particular appellant, number 1G, had no notice who was the lawyer, taking into account that she had filed an additional affidavit before this court on 3rd of April 2013? How is it possible?
That means
False statements. She was the person who signed the affidavit
on your lordship.
on 3rd of April 2013. Then 1A, you say that appellant number 3 was the person who was interacting. But what 1A was the person who filed the affidavit, the miscase asking for stay.
The stay application.
Then isn't it all false statements being made on an affidavit on oath?
That is what has been conveyed to.
We initiate 340 proceedings against these people.
One A has expired. he said.
Huh?
1A, he says that it's expired.
When?
And he-
1E expired.
One. Kakuli Deva expired.
Kakili Bewa
Kakila
expired.
Deva expired.
Are you saying that Kakili Bewa expired?
Yes,
Who expired? 1E or 1A?
1A, Kakila Deva.
Huh? So then why do you want one
That was
E?
earlier. Yeah. That was earlier, I think. That was long back. One A expired long back,
When?
and he has been substituted by his legal heirs, Your Lordship.
Where is the question of substitution of the legal heir?
Among the legal heirs were there, so she has expired long back, and as the legal heirs of Joymurthy, Jyotimuddin Sheikh were already on record, so they were not he was not substituted. He was not replaced. A few substitutions have already taken place before we came into picture.
Okay. Now on merits, what's your case?
Lordship, the case in brief is, Your Lordship, as per the appellant's case,
What is this substantial question of law?
the substantial question which has been framed, Your Lordship, was with regard to section 34 of the specific relief act.
Why?
The contention is that in the entire relief has not been sought for.
Did you raise that issue in the written statement?
Yes, it was there, Your Lordship.
Where?
Specifically, but it was not elaborated upon. But
Elaborated
specific
nothing, or you cannot raise that.
WS, Your Lordship, you will find.
Decree for declaration of the plaintiff's right, title, and interest and possession in the land of so and so. Decree for declaring that so and so. A decree declaring that sale deed dated so and so. A
Para
decree
5 of the
declaring that
WA.
the plaintiffs are entitled to separate patta for a year. Alternate decree entitled to partition. What is, why you are saying about 34?
34 in para 5, they have stated.
Why?
The sense is that not all the legal heirs or the entire relief of partition had not been sought for.
What entire relief of partition has been sought?
Strangely, Your Lordship, though the substantial question was framed, there is no elaboration with regard to in the WS also.
So
So that apart, there
we
is,
substitute then and dismiss your appeal.
Your Lordship, another thing is there, Your Lordship. Your
There's
Lordship
nothing.
sees-
I don't go by this 2010 substantial question of law has been framed, that is it, and this is, has no relevance out there.
Another thing, Your Lordship, in the Lordship, in this case, they have sought for the suit was with regard to a sale deed, which was executed in 1997. And the alleged dispossession took place in 1997 February. The suit appears to be filed in 2010. So though there was no specific issues framed, Section 3 of the Limitation Act is there, Your Lordship, which says that even if a specific defense is not framed, that may be looked into by the trial court to appreciate that. Now, Your Lordship will find in the plain, even they have admitted in the cause of action has arose and the sale deeds they have challenged
Hmm.
are of 1997.
Hmm.
In the plaint, they have stated. We are the buyers of the original. Para 13 of the plaint. And para 7 of the plaint here.
It was filed in 99. Why you're saying about 2010?
Your Lordship, that is copy.
Mr. Biswas, are you not aware about the facts? Now tomorrow another counsel will come up and say that, look here, this person concerned, this lawyer, we have not engaged him also. Did you sign a wakalatnama or not?
It's taken my signature.
Have you signed your
Yes, sir.
wakalatnama or not? Where's your wakalatnama? You have signed or not?
It's taken my signature, I have signed.
Yes. How did you raise that issue of limitation?
And another
Because
issue,
they categorically say that they came to only know in 1997. Suit was filed in 99. How's the question of limitation is there?
the only thing then your Lordship remains with regard to section 34.
So 34, we dismiss it on that ground.
That is the only ground it is there because, and I cannot argue on a point.
Let us end the misery of this case.
Your Lordship,
We substitute and dismiss.
the only
Madam?
other thing is,
We substitute and dismiss.
Another
And
thing, Your
as per the rate, it goes 22,000.
another thing. Just- That the issue with regard to section 34, your Lordship will find that though various parties have been stated to be the specific relief of partition was not sought for with regard to the particular Khatian and Dag number.
Mr. Counsel,
That
are you
is
going to submit that the suit for partition is the relief of partition is a further relief?
the relief in the sense they have stated.
No, is
That is not a
is
consequential
the
relief.
relief of partition a further relief? No,
It is not a consequential relief.
it is not a further relief coming within the ambit of the proviso.
That is not a
He
consequential.
has asked for recovery of possession.
They have asked in the sense, your Lordship may see the prayer that interest and possession of Schedule B land they have paid reach 40.
Here, can you see, page 41, a
Page
decree for
40, yeah.
permanent injunction restraining the defendant from agent from dispossessing the plaintiff from the suit of the Schedule B and disturbing therein in so and so. So,
And they have sought that the declaration that defendant have no right title interest to sell of this land to us.
uh,
So we are claiming it on the basis of 3 sale deeds which had been executed by the defendant number 1 to 12. And the decree declaring that this sale deed, we do not have any right over the Schedule B land. and a decree that is entitled to get separate patta with regard to the land. And the declaration is entitled to partition of the Schedule A land as per the provision of the land revenue regulation
Then,
and the possession thereof.
so here the consequential relief is what? When you were in possession?
And because
The consequential, the further relief is for an injunction at best.
and bounds, maybe that was the contention, not sure. But from there, what is there in the
No
pleading-
case.
What is there in the pleading, it appears that the issue, substantial issue that was framed, it was based on a single para in para 5. That is order to rule,
Order to rule to is if a person concerned has various other reliefs but does not claim a relief, he cannot at a later stage claim that relief, which will come in respect to another suit.
not, another thing, your lord.
A suit cannot be dismissed on that ground. But in view of section 34, that you cannot give a barely a declaration if there is a further relief without seeking a further relief. Now, for that, you have to categorically mention in your plain written statement, which is not there. So your case has to fail.
And the appellate court had taken that note. I have seen that.
Yes.
Appellate court has taken this, that there was no elaboration with regard to that.
And there is a judgment of the Supreme Court, 61 Supreme Court. Yes. Dismissed with cost
Okay,
of
cost,
22,000.
uh,
22,000, it goes by the saying. Yesterday onwards, I've started. Chalo. All these applications are taken up together for disposal by this common order. Full stop. The 5 applications are taken up together by this common order. IAC number, which is the condonation,
continue. One eight five three.
hmm?
1853. One eight five three, ISC 1853.
Does said applications relate to substitution of the legal representatives of the appellant number 1E, appellant number 3, as well as the respondent number 1, who expired on 21/6/2022, 14/4/2017, and 8/5/2019, respectively. Ms. R. Chaudhary, the learned counsel who represents the respondents, submits that she has no objection in allowing the instant applications. Subject to the appeal being taken up for hearing, inasmuch as the appeal has been pending for the last 15 years. Full stop. Taking into account the above, comma, these 5 applications stands allowed, thereby condoning the delay, setting aside the abatement, and substituting the legal representatives of the respondent appellant number 1E, comma, appellant number 3, and the respondent number 1 with the following. The appellant number 1E is substituted by, where is that application?
They filed 5 applications, one condonation for one appellant 3 and one condonation for appellant number 1B. 2 substitution, one for appellant number.
I am allowing it there. I only want the substitution application for 1E. 1B died,
Yes,
not 1E.
On the
1B.
B.
1B cannot, it doesn't require to be substituted because they are already there.
A is there, Lordship.
1A
Other
is
legal
there.
heirs of 1A is there, but 1B has to be substituted.
Who died, 1E or 1B?
1B died.
1B.
Yes,
I do 1E equal to 1B equal to. Where is that application?
your lordship will find.
Oh, not ready, these people.
1855.
18?
1855
1855.
of 24.
And for
1A, 1B, huh?
1B substitution,
1B
1855.
is substituted by the names of, by his legal representatives whose names have been mentioned as at paragraph number 3 of IAC number 1855/2024. And they are arrayed to the memo of appeal as appellant number 1B bracket 1, 1B bracket 2, Roman 2, 1B bracket 3, 1B Roman 4, respectively. Appellant number 3 is substituted. Appellant number 3 appellant number 3 is where?
Appellate number 3 is 1856.
It is seen that the appellant number 3 is survived by his legal representatives whose names have been reflected in paragraph number 3 of IAC number 1856/2024. Full stop. Accordingly, appellant number 3 is substituted by his legal representatives as appellant number 3.1, 3.2, and 3.3. Full stop. Full stop. The respondent number 1 is survived by his legal representatives whose names appear at paragraph number 3 of IAC 1853/2024. And the respondent number 1 is substituted by his legal representatives, and they are arrayed in the accompanying appeal as respondent number 3.1, 3.2, 3.3, and 3.4. All the 5 applications stands allowed, the counsel appearing on behalf of the appellant is directed to file a fresh memo of parties before the registry of this court within 7 days from today, and the registry shall on the basis of that make necessary correction in the memo of appeal and update in the CIS. Now appeal to look. Heard Mr. A. Biswas, the learned counsel appearing on behalf of the appellant. You have filed the wakalatnama? Signed it? Okay. And Ms. R. Chaudhary, who appears on behalf of the respondent numbers 2, appears on behalf of the respondent numbers 2A to 2G, 3, 4, 5, 6, 7. Full stop. She further submits that she has instructions to appear on behalf of the newly substituted respondent numbers 1.1, 1.2, 1.3, and 1.4. So, respondent number 1.2. Full stop. This is an appeal filed under section 100 of the Code of Civil Procedure, challenging the judgment and decree dated 30/4/2010, passed in title appeal number 37/05, whereby the appeal was dismissed, thereby upholding the judgment and decree, affirming the judgment and decree dated 37/2005, passed in title appeal number 307/99 by the Learned Court of the Civil Judge Junior Division number 1, Dhubri. Full stop. Agortu koi dibo, une appellate court hol Civil Judge Dhubri. Agortu Civil Judge Dhubri, first appellate court or it. Full stop. It is seen that the Learned Coordinate Bench of this court, by an order dated
28/2010.
20/08/2010, admitted the instant appeal by formulating a question of law which reads as under, inverted comma, whether the appellate court misread the provisions of Order 2, Rule 2 of the Code of Civil Procedure 1908 and Section 34 of the Specific Relief Act 1963. And if so, what will be its effect? Question mark. The question arises before this court as to whether the said substantial question of law so formulated by the Learned Coordinate Bench of this court is involved in the present appeal. Full stop. For ascertaining the same, this court briefly would like to take the facts which led to the filing of the present appeal. Full stop. The respondents herein, the respondents herein, as plaintiffs had instituted a suit seeking various reliefs full stop. Taking into account the substantial question of law so formulated by the Learned Coordinate Bench, comma, this court finds it apposite to reproduce the reliefs which have been sought for by the plaintiffs in the said suit. Page 40 to say, or 41. Full stop. The facts on which the plaintiffs have instituted the suit is that a plot of land at measuring 6 biga 1 katha 19 lectures recorded in a single dag number 119, na?
Yes.
119?
And 59 is the single Khatiyan.
118, dag number 118. Of final Khatiyan number 59.
Yes.
Stood jointly in the names of 8 Khatiyandars, namely Tasadi Sheikh, Punna Sheikh, Sarbeswar Roy, Rajeshwar Roy, Kalisharan Roy, Baljit Chandra Roy, Kamala Kanta Roy, and Jogyeshwar Roy. Full stop. It was mentioned that though the land happened to be recorded in the joint Khatiyan, comma, Tasadi Sheikh, Punna Sheikh, were in no way related to the other Khatiyandars, and they used to own and possess separately the southern half part of the plot of land, while the northern half plot of land was possessed by the other 6 Khatiyandars. Full stop. It was further mentioned that except Bolit Chandra Roy and Jogeshwar Roy, all other Khotiandars have died. Full stop. While Sorbeswar Roy, Rajeshwar Roy, Kalisharan and Kamalakanta Roy have been succeeded by the defendant numbers 1 to 11 and 14 to 19, Puna died, leaving his only niece, Urmani Devi, the wife of Tasadi Sheikh. Later on, Tasadi Sheikh also died, followed by wife Urmani Devi, son Kokamant Sheikh. The plaintiff number 1 and 2 and the performer defendant numbers 1 and 2 are the surviving sons and daughters of Tasadi Sheikh, while the plaintiff number 3 to 8 and performer defendant number 3 to 7 are the heirs of Kokaman Sheikh. They all inherited the part of the land left behind by Puna Sheikh and Tasadi Sheikh in the Khotian number 59, and by family arrangement, the plaintiffs have been using and possessing the same as described. Full stop. It was further stated in the plain that due to construction of the road touching the western boundary of the plaintiff's part of the land, the total area of the Khotian number 59 measured 6 bighas 1 katha 1 lecha. During the recent and ongoing settlement, during the conducted settlement operation, and was fraudulently managed and recorded in the name of the defendant number 12 in two names of Kalisharan Roy and Jogeshwar Roy in Kacha Patta number 127, Dag number 274, which was subsequently brought under Patta number 127, Dag number 274, and the Patta number 731, Dag number 274/1096 as described in Schedule A. Full stop. An objection was filed during the fuel mutation, and the names of some of Tasadi Sheikh were included, sons of Tasadi Sheikh was included in the Patta by order they passed by the ASO Sopor on 22/1/1997 in mutation case number 38/96. Full stop. It was further stated that excluding the 3 bighas 0 kotha 19.5 lessons belonging to the defendant numbers 1 to 19 from the northern part of the Dag number 274, the plaintiff possessed 3 bighas 0 kotha 1.5 lechas from Schedule A covered by the entire Dag number 274/1096 and the contiguous southern part of Dag number 274 as described in Schedule B. It was alleged that the defendant number 1 to 12 conspired with the defendant numbers 20 and 22, who illegally tried to trespass into the plaintiff's land in the month of February 1997, whereupon the plaintiff number 1 filed miscase number 92/97 before the SDGM ex Bilasipara, Executive Bilasipara, wherein the suit land was attached under section 145/146 of the CRPC on 6/8/1997, but the same was vacated by the Sessions Court, Dhubri, on 28/11/1997 in CR case number 30/97. Full stop. It came to the, during the said proceedings, it came to light that during the said proceedings, being miscase number 92/97, it came to light that the defendant numbers 1 and 12 were claiming right over the sale deed numbers 1 on the base, claiming rights over the suit land on the basis of sale deed number 1228, 1229, 1232, dated 4/6/1997, which was executed fraudulently. and behind the back of the plaintiff. Full stop. On coming to learn, the plaintiffs filed a suit being titled suit number 346/97 before the Court of the Civil Judge Junior Division Dhubri for appropriate relief. And during the pendency, they also came to know about another deed, being deed number 1232 from the written statement filed by the opposite party in Miss Case number 92/97, which ended indecisively with a direction to the complainant to seek relief in the civil court. Full stop. Thereupon, there were certain talks of compromise, which, however, did not lead to a resolution to the dispute. And under such circumstances, the suit was filed, seeking the reliefs as above mentioned.
There was other suit appears from this, that before that, they had sought for a cancellation of the sale deed by a particular suit.
That was withdrawn.
That was withdrawn, but that relief is surprisingly not, they are seeking declaration that they were executed by fraudulent means, that for sale
Which
deed.
one? This has been done.
Declaration, seeking a declaration whether the sale deeds, the only relief they are seeking is that they cannot execute the sale deed. And we do not have any right on the basis of the sale deed. But the specific relief with regard to declaration that the 3 sale deeds were executed fraudulently does not appear to be there in the prayer portion. Though the earlier the suit they had filed had been, it was there, but they had been withdrawn, Your Lordship.
A decree has been sought at paragraph relief B. You have not read it properly.
Separate, they are saying that no right to sell, Your Lordship, but a decree of a registry.
Why you are not reading the entire relief properly?
That the deeds executed these purportedly to transfer are illegal and not binding upon this plaintiff.
To transfer the entire land of Khotian are fraudulent, illegal, and not binding on the plaintiff. Then, stop. It is seen that in the suit, the defendant numbers 12 and 20 and 22 filed their written statement, wherein various pleas were taken . Various preliminary objections were taken, including the preliminary objection that the suit was bad under Order 2, Rule 2 of the CPC and under Section 34 of the Specific Relief Act.
Okay, sorry to interrupt. Out of the 3 sale deeds, it appears that only 2 sale deeds have been specifically assigned. 1232, though they have stated in para 7 that we are claiming rights on the basis of 3 sale deeds, the relief as well as the thing is only dealing with only 2 sale deeds.
No. He says 1228, 129.
And 1232 in para 7, which Your Lordship had just read.
He says on the basis, these 2 sale deeds should be set aside and quashed.
Means
As regards the 3 sale deeds, prayer number C is there, 1228, 1229, 132.
but they have not sought for a that particular sale deed also to be fraudulently executed, though they are only 2 they are seeking, it is fraudulently executed.
I have said that no, have not acquired any right, title, and interest.
Understand that, but as they have claimed with regard to the 228 and 29, specifically, it had been illegally and fraudulently executed. No specific prayer with 1232 appears to be lacking, Your Lordship, with regard to that fraudulent part, Your Lordship.
Hello, we'll consider it and pass orders. I'll take care of that. Don't worry. Pusto. In the written statement, it was categorically stated that the defendant numbers 20 and 222 purchased the land measuring 6 bighas 2 kata 19 lechas, that is Schedule A land, and got delivery of possession and have been possessing the same. Full stop. It was mentioned that the title suit filed earlier, being title suit number 346/97, was dismissed on 24/9/99. And as such, on the principles of res judicata, the subsequent suit was not maintainable. It was further specifically mentioned in paragraph number 17 of the written statement that the plaintiffs were not in possession of the Schedule B land. Additionally, it was mentioned that late Purna Sheikh and late Tasadi Sheikh had no right, title, interest in the suit land. And accordingly, the plaintiffs have also no right, title, and interest over the suit land. On the basis of the pleadings, the learned trial court framed as many as 13 issues, which being relevant is reproduced hereinunder. Page 29, 30 the same. Issue number 5 is in connection with the substantial question of law. First, it is seen that the learned trial court, while deciding the said issue number 5, observed that there was no material particulars either in law or on fact in the pleadings of the contesting defendants to show that the suit is bad under Order 2, Rule 2 of the Code and under Section 34 of the Specific Relief Act. And it appears that the issue was framed mechanically and hence struck off. Full stop. This court further finds it relevant to take note of the discussion in issue number 9. Issue number 9 and 10, whereby the learned court below, after taking into account the evidence on record, came to a categorical finding that the plaintiff have got right, title, interest along with possession over the Schedule B land. This aspect of the matter is being taken note of, taking into account that it also touches on the proviso to Section 34 of the Specific Relief Act. On the basis of the discussion on the various issues, the learned trial court decreed the suit in favor of the plaintiff by declaring the right, title, and interest of the plaintiff over the Schedule B land and their possession thereon was confirmed. The registered sale deed numbers 1228, 1229, 132 dated 4/6/97 of the Dhubri Sub-Registry Office executed in favor of the defendant numbers 20, 21, and 22 were declared fraudulent, illegal, and not binding on the plaintiffs. It was also declared that the plaintiffs are entitled to get separate patta in respect to the Schedule B land. The defendants were perpetually restrained from dispossessing the plaintiff from the Schedule B land. However, the learned trial court was not inclined to impose any costs. Being agreed, the defendants filed an appeal before the learned court of the civil judge, Dhubri, which were registered and numbered as title appeal number 37/05. It is relevant at this stage to take note of the grounds of objection so taken in the memo of appeal so filed by the appellants before the learned first appellate court insofar as Order 2, Rule 2 and Section 34 of the Code, as well as Section 34. The said grounds of objection are mentioned at where grounds of objection number 4 and 5, which is reproduced here in under. From the said grounds of objection so taken, it transpires that mechanically the appellants, without reference to any facts, refer to Order 2, Rule 2 and Section 34 of the Code, as well as Section 34. Without stating with clarity, even after the decision of the learned trial court in respect to the issue number 5, as to how Order 2, Rule 2 of the Code and Section 34 of the Specific Relief Act 1963 would be involved. The learned first appellate court duly had taken note of the said submissions so made in respect to Order 2, Rule 2 and Section 34 of the Code and Section 34, as would be apparent from the judgment of the learned First Appellate Court. And observed that for the purpose of application of Order 2, Rule 2, the suit, comma, it has to be only in respect to a subsequent suit. And as the said suit was not a subsequent suit, comma, the question of Order 2, Rule 2 of the CPC did not apply. It is further relevant to take note of that the learned trial court, First Appellate Court, by the judgment and decree dated 30/4/2010, dismissed the said appeal by affirming the judgment passed by the learned trial court. In the backdrop of the above, let this court now consider as to whether the substantial question of law so formulated is at all involved in the instant appeal. First, Mr. A. Biswas, the learned counsel appearing on behalf of the appellant submitted that a perusal of the relief which have been sought for would show that in relief number B, there is no declaration sought for that the deed of sale bearing deed number 1232 was fraudulent, illegal, and not binding upon the plaintiffs. And therefore, without the said declaration sought for, the suit, the deed, the sale deed number 1232, dated 4/6/1997, could not have been declared to be fraudulent, isn't it? It is relevant to take note of that a perusal of paragraph number 11 of the plaint, it has been categorically mentioned under paragraph number 7 and 11 of the plaint. It is categorically mentioned that the said deeds numbers 1228, 1229, and 1332 were fraudulently executed behind the back of the plaintiffs. 8, 9, 7, 11, and 12. First, it is relevant to take note of that the well-settled principles of law stipulate that the plaint has to be read as a whole and not merely based upon the reliefs and not merely on the basis of the reliefs so sought for. In this regard, reference can be made to the judgment of the Supreme Court in the case of which one? Mr. Biswas, which one? Yes, madam, which one? That 1989? The Bangalore at a judgment it was 1989. So and so. This court further. First, Under such circumstances, the said submission is misconceived. First, the learned counsel, now coming back to the issue, coming back to the substantial question of law, it is relevant to take note of that the reliefs which have been sought for would come within the ambit of further relief as mentioned in the proviso to section 34 of the Specific Relief Act. The learned counsel appearing on behalf of the petitioner, appellants, though submitted, that a relief have not been sought for specifically in respect to partition of what? Partition for?
Because they are saying that we are entitled to Schedule A part, but Schedule B is their part. So on the northern part, the demarcation between the Schedule A and B, there is no specific partition has been sought for. Though, because their contention is that the sellers are entitled to sell a portion of the Schedule A land, which is in the northern part. But as per their contention, that we have transgressed into their share
Is Schedule B.
Schedule B.
Then
So
what else is required?
that part from the sale deeds, because the entire sale deeds are not per se can be said, because only those parts which falls into Schedule B would have been the sale deeds. They are not seeking any demarcation between the Schedule B land and A, because they say that merely occupying that, there is no specific demarcation plea is made before the.
Submits that that there was no specific demarcation sought for in taking into account that the deeds of sale made by the defendants, numbers, who sold this? 1 to 12, in favor of the defendant numbers 20 to 22. 22, included the entire Schedule A land. And therefore, there was a requirement of a partition which ought to have been sought for. First, the said submission, in the opinion of this court, does not appear to be in accordance with law, does not appears to be misconceived, taking into account the relief sought for at serial number D of the plaint. Accordingly, the substantial question of law so formulated by the learned coordinate bench by the order dated so and so, in the opinion of this court, is not involved in the instant appeal. First, this court, however, accordingly, the appeal stands dismissed. First, before parting with the record, this court, however, finds it very pertinent to observe that the deeds of sale bearing deed numbers 1228/1229 and 1232 executed by the defendant numbers 1 to 12 in favor of the defendant dated in favor of the defendant numbers 20, 21, and 22, all dated 4/6/1997, relates to the entire Schedule A land, and Schedule B land is the land which the plaintiffs claim. First, considering the above, this court therefore observes that this court, therefore, in exercise of the powers under Order 41, Rule 33, observes that the sale deed modifies the decrees so passed by the learned trial court, thereby with the observation that the sale deeds numbers 1228, 1229, and 1232 dated 4/6/1997 shall not be binding upon the plaintiffs insofar as the Schedule B led, which was the relief sought for at Schedule C. Full stop. However, the sale deeds bearing sale deed number 1228, 1229, 132 dated 4/6/97 shall be duly operative in respect to the remaining part of the Schedule A land, excluding the Schedule B land. With the above, the instant appeal stands disposed
Highly obliged.
with cost of 22.
Cost maybe
No, I've modified it, so no cost.
highly obliged.
Yes, Mr. Hussain?
This service has been taken, my lord. I filed the evidence. So there is, I also filed it at section number 6161 is the trial court here. So there is section 57.
Justice Service.
Yes, my lord.
Justice Service, you have to enclose the dusty.
The system is not ordered. So I have,
No, where is the dusty you have enclosed?
that is already sent.
Has it been served?
Not served, my lord.
Then, if it is not served, then how is it possible?
That it is already served from the further discussed from the court. So the civil Nazir Barbata,
How do you know?
I myself personally, they handed over with the party. We were the civil Nazir.
But Mr. Hussain, this is not a dusty service. You don't do the dusty service in this manner. First of all, you have to file it. And you have to file the dusty, not in this manner. The dusty has to, you have to
Already
enclose the
recorded,
dusty.
already I have handed over for the civil Nazir Barbata.
That has been served, it is okay, but this cannot be termed as the affidavit of service. Because there it has to include the dusty, wherein the sign is there, and you have to specifically say that this is the person who has received it. Where is it? There's nothing out there.
Service report maybe going to take. That's already the matter handed over to the civil Nazir. It's an under section 1, you can also file.
Both the suits are pending in the same court.
Yes, ma'am.
No, we do one thing, we have it on some other day.
Well.
There's already a stay.
Yes.
Uh, The respondents have not appeared in spite of service being duly effected, as would be seen from the office note dated 19/2/2025. Mr. B. Hussain, though submitted that Dusty service have been, the steps as regards Dusty have been taken, but the affidavit of service have also not been filed. Considering the above, this court fixes this matter again on 4th of August 2025, the petitioner is directed to file the affidavit of service on or
File.
before the next date. Full stop. The interim order passed earlier shall continue till then.
Nothing.
Very challenging.
Second, 41, item 41. But my suit was for special performance of contract. And there, prior to that, the respondent number 4 have got a decree for specific performance against the respondent number 1 and 3. And against him, in respect of the same name and against the same defendant. So that decree stands. Therefore, I have to file another suit for declaration that decree was a policy one. So I have filed. Thereafter, I have filed an application under 51 for keeping in abeyance my suit, which was filed by me for special performance. That was rejected. Against that, I have come.
Why?
Because against this, in respect of the suit land, already obtained by somebody else.
So without the setting aside of that,
Milord, I have to file suit for set aside that judgment because that judgment was a policy one. And my lord, at the same time, I have filed an appeal also against that judgment as a third party before this honorable court. That is also at the condonation stage and leave has not been granted yet.
so then
Thereafter, this honorable court has issued notice in respect of the revision petition as well as in respect of interim prayer. So, when the case was taken up by the trial court, I have filed an application that the matter is in session before this honorable court. So, cross-examination of the different DWs, the HO, that was rejected and case was fixed for argument. And therefore, the second division petition.
second is 345.
345.
And that order has been stayed.
Yes, ma'am.
So that order has been stayed means the suit is stayed.
Suit.
So this is the second suit.
Milord.
This is the second suit.
Second, first, the suit filed by me, but
So that suit has been stayed.
now it is stayed by this honorable court. I will have that 345.
And the other one is
Other one is for that
challenging the 151 application, rejection of the
rejection
151.
of.
And here the court have not stayed it.
My God. And I'm seeking my suit to be Milord stayed.
Now, because the suit, if the suit cannot, there cannot be a contradictory decree.
My God. Because it's up to him to take a stand. He has taken a stand to choose to stay, to keep in abeyance his consequences to follow. I have no objection. We have thought it out. But perhaps subsequently he may not fail. That liberty will not be granted. He has chosen for a stay, let him stay. We are giving him. I am a person against whom he is aggrieved because he says in collusion with the owners, we have sought to arrange to get benefit of a parcel of land. Therefore, he seeks a specific performance of a contract. By another suit instituted by me way earlier, my suit for specific performance of contract was decreed.
So you are a party in the second suit.
Both suits.
Why?
He has instituted only one suit. We come to that. There's a parcel of land ABCD. There are two agreements for sale to it. One the owners make with me, and the other owners.
You are the
make it.
purchaser.
Absolutely.
You have purchased it. So why you are a party in the his suit?
He challenges the decree of mine, judgment passed in suit X.
No, he has filed two suits.
Yeah, absolutely. He challenges the decree
No,
of
no, the
mine.
first suit is.
First suit is seeking for specific performance of his one, which
So
cannot be
there,
granted.
there you are not a party.
I am a party.
How?
That's point number 4. Yes, yes. Debate number 4.
How he is a party in that suit?
Because we got, because he has also fight without making me party. I wanted to be completed. I was not allowed. That is the fight. And later on, the suit was decreed because the vendor
Now, who appears for the vendors?
right now nobody has it.
Service is not complete.
Yeah, in respect of 345 service is complete. In respect of 201 not complete.
Why? Why?
I have taken note steps, but that office note has told me that.
Hello, you take service by way of the state upon this. Response numbers 1, 2, and 3.
I started before started trial court also.
Maybe in which court?
Uh,
In your first suit,
First,
it's proceeding ex parte.
expert.
And he is appearing
He is appearing, he is contesting.
in the first suit.
First suit.
And in second suit
In
also.
second suit, he has appeared, and the other 3 has not.
Second suit is not before me.
Yes,
No.
sir. First suit, I ought not to have been a party, but he arranged me as a party and contesting.
Chalo. It is seen. Heard Mr. Saud, the learned counsel appearing on behalf of the petitioner, as regards the respondent number 4, Mr. Esbernik appears. CRP IO 201/2024 arises out of a rejection of an application filed under section 141 for stay of title suit number 48/48
246/19.
246 of
19.
no 429.
The
Stay of
429,
which suit?
429 is the second one.
Stay of title suit number.
246/2019.
Where is that? Where do I get anywhere? 246/2019, whereby the application filed by the plaintiff for stay of the said suit was rejected pending disposal of the subsequent suit being title suit number
429/2023.
429/2023, pending before the same court. Mr. S. Sahu submits that as title suit number 246/2019 pertains to a suit seeking specific performance of an agreement for sale dated
18/7/2013.
18/7/2013 between the petitioner, who is the plaintiff, and the defendant numbers 1, 2, and 3, who are the respondent numbers 1, 2, and 3 herein. And the said suit land having been collusively sold by the defendant numbers 1, 2, and 3 to the defendant number 4, who is the respondent number 4 in the instant proceedings. The subsequent suit, being title suit number 429/2023, was instituted. He therefore submitted that till the decree so passed in title suit number 48/2015, on the basis of which this land, which is the subject matter in the agreement for sale dated so and so in 2013, have already been transferred in favor of the defendant number 4
By execution for the 2021-34.
by the defendant numbers 1, 2, and 3 pursuant to the judgment and decree passed in title suit number 48/2015. The question of granting a suit for specific, granting a decree for specific performance pursuant to the agreement for sale dated 2013 does not arise till the judgment and decree dated passed in title suit number 48/2015 and the subsequent execution of the deed of sale in favor of the respondent number 4/the defendant, respondent number 4 is not set aside. He therefore submitted that the therefore, the petitioners had filed the application under section 151 for stay of title suit number 246/2019. This court, having taken note of the contents of title suit number 246/19, the judgment and decree passed in title suit number 48/2015, the deed of sale executed in pursuance to the judgment and decree passed in title suit number 48/2015, as well as the subsequent suit filed, being title suit number 429/2023, is of the opinion that the learned trial court ought to have stayed title suit number 246/2019 pending disposal of title suit number 429/2023, inasmuch as the said suit, being title suit number 246/2019, under no circumstances can be decreed unless and until the title suit number 429/2023 is decreed in favor of the petitioners. Consequently, this court therefore interferes with the order dated 9/4/2024 passed in title suit number 246/2019 and states and allows the application, being petition number 6446/2013 filed under section 151, and stays title suit number 246/2019 till the disposal of title suit number 429/2023. Accordingly, the instant petition stands allowed. Mr. S. Sahu submits that the second petition had become infructuous in view of the order passed in so and so, for which he submits that he may be allowed to withdraw accordingly proceedings. What is remains? What remains there? I've already stayed the suit.
But he has not challenged the same.
You have not challenged the sale deed.
Obliged lordship.
My lord. Sir, salary, yes, my lord, I'm not going to.
You have not challenged the sale deed.
Otherwise, no way out.
Decree
I
is
can't
done,
be
my lord.
talking.
Sir, decree is done, so restoration is there, my lord.
Huh?
Restoration is there. Restoration is there. Suppose decree is in my favor, because at the time of filing of the case, it is not the case, we didn't have knowledge that that was sold.
A sale deed challenge করণাবলী কই দিব challenge করণা এটু কিন্তু হেখন ডিগ্রি কথা I am not mentioned about the sale
Obliged,
deed challenge.
Wait. Give you.
So this will be stayed. But the other one become infructuous. Withdrawn. Where to where? Where do you want to go?
From Tezpur to Nagaon, my lord.
Tezpur to Nagaon. So,
But this petition is pending before the Tezpur District Judge Court, and this is not a family court. Her day-to-day appearance physically is not necessary in view of section 13, what is required before the family court. And the only ground she has mentioned here that she has a child who is 2 years old and no income. This is the only two grounds. But she may very well, if there is no income, she may very well engage a counsel from legal aid and her appearance before the court, because it's a case.
when I joined, I paid 2021, I made it 3,000. Now I make it 5 years down the line, 7,000. You go there, 7,000 he will pay. Every appearance.
But the
Every
fair,
time you appear, Nagaon to Tezpur, pay 7,000. Okay. Hello, we dismiss it, you pay 7,000. Whenever. What is she going to do? She has no money. Every month she needs some money.
this is only a statement made before this honorable court, and there is no particulars regarding her income or anything else.
What does she do? Are you admitting? Do you say that she does she do anything?
She has filed a domestic violence case before the Nagaon court, madam. She is very well contesting there. There she has money. And here to contest madam, this suit is filed for restitution of conjugal rights. If she doesn't want to go, then very well by way of a statement before the court, she can very well express her willingness that she doesn't want to go. That matter will be closed. And
No, the
for this-
matter will not be closed. There will be a decree.
Yes, there will be decree that.
And then there you will attach her properties.
No, the attachment will come only where there is a decree in favor of.
You.
Yes.
So you mean that he should go away and say that, okay, I have no problem of that.
No.
And
if
pass a
she-
decree.
If she expresses her willingness through a council, and she doesn't need to appear before the court, it's only a conjugal right. There are-
You have no problem of that. Answer.
This honorable court has passed several judgments, orders, indicating that in the family court, there is a requirement in view of section 13 of the Family Courts Act, personal appearance is necessary. Before the district judge court, there is no requirement of personal appearance. Only because she is a lady, there is a sympathy always, my lord, in favor of the lady fraternity with due respect. But so far as the man are concerned, he is a teacher, school teacher, merely earning 15,000 per month,
Who?
the husband.
And you can't go to Tezpur.
But I am from Tezpur.
And you can't go to Nagaon.
Nagaon, my lord, if.
You have you have difficulties. And she has no difficulties.
Has difficulty. So he does not appear before the court personally, as we require under the Family Courts Act.
You also don't have to appear personally. Go there and engage somebody else.
Right, but right demands after inquiry, they have to file the petition and rightfully file the petition before the court who has the jurisdiction. Well, every time on this Anindita Das case, Supreme Court has held that only particulars, and subsequently this honorable court also relying on the Anindita Das case held that only saying that she doesn't have any income will not suffice.
unless and until the particulars are there, that she doesn't have any income, she has difficulty, there also the same pleadings were there.
Transferred. You filed your written statement?
Not filed, my lord. My lord, the numerous occasion, my lord, she did not appear. Cost was imposed on her 10,000 rupees
I have
by the
already
court.
Oh, that one. No, she is imposed. I didn't pass the order. She they filed the written statement and willing to pay the cost. You paid the cost. Paid. Mr. Biswas, this court did not pass the order first. First date, on 28/2, I said that shall produce the court's order. Second date, I said that the next date is fixed on so and so for payment of cost. It has been submitted. The petitioner is willing to make the payment of the cost, and it is only on the payment of the cost.
But that's the instruction I do not have whether he has paid, Through my counsel, I came to know that she has not paid yet. This is my instruction. This is only my instruction. I'll verify it.
Lordship,
I'll verify it.
Submitted the order, Lordship. That is reflected in the order.
Oh, yes, he has submitted. I remember. Where is that order? That payment of cost was given. Where is that?
The CIF
Huh?
the CIF of the case also reflected that I have already paid.
It's reflected. No, he showed me some order. Otherwise, I was not intended. I didn't intend. What he was trying to do was this. Without paying the cost, he wanted a transfer. Isn't it? And I caught hold of him. Transferred. Transferred. You go and file your written statement on, when is that? 4th of August.
Obliged.
What is this?
Prepared an application under order 21/97,
Huh.
third party against a decree,
Huh.
that application has been rejected against this present revision.
How is it maintainable? How is it maintainable? Isn't it a decree? In terms with 103.
We a decree, because I was a third party, in this case.
Third party only it becomes a decree. Otherwise, it doesn't become a decree. Otherwise, you cannot file under Order 21 Rule 97. Then, Mr. Asdit Shiladitya, the learned counsel appearing on behalf of the petitioner submits that taking into account that the order which have been assailed in the instant proceeding pertains to an order passed under in exercise of the powers under Order 21, Rule 100 in an adjudication under Section 100, Order 21, Rule 100 and 101, comma, it would be a decree in terms with Order 21, Rule 103, comma. He would not like to press the instant petition. However, he submits that he may be permitted to file an appeal thereagainst before the appropriate appellate forum. And the period during which the instant proceedings have been pending be excluded while computing the period of limitation. Taking into account the above, comma, this court allows this court closes the instant petition on withdrawal, comma, the petitioner would be at liberty to file appropriate appeal, file an appeal before the regular first appeal before the appropriate before the competent court against the order dated 14/8/2023 passed in Mizzi case number 22/2023. The period from 2/9/2023 till date be excluded while computing the period of limitation. What?
Not prepared,
They know what to do. I did not say anything. You show that 103 provision, it's a decree, they will know. Vacated, dismissed. Interim orders, if any, stands vacated. Yes. You filed your wakalatama?
I've already
See?
filed.
What do you want now?
I know the timely be given, in the meantime, I will collect the copies from the registry by certified copy.
Whether the learned lower appellate court in law erred in law in deciding the issue of res judicata against the plaintiff appellant, thereby dismissing as not maintainable. Argue?
No file, my lord, I am,
No file.
yes, my lord.
Okay. Your name?
Atish Sheikh, my lord.
Mr. Counsel, you made a mention in the morning and said that you have not filed the wakalatnama, and you make an audacity, have the audacity to make that submission before the court in the morning when you appeared before this court on 8/1/2025
That
and made the similar submission before the court.
the practice, my lord.
No, the
8-1,
question does not arise. Today we are taking
Please,
up for
my-
disposal of this.
my lord,
No, 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 no. We have to dismiss this.
yes, my lord.
petition.
Thereafter, after.
Why
8-1,
on earth did you make a submission in the morning that I have been recently engaged and I don't have not been given the file? They are going to give me the wakalatnama. Wait. And the same submission made 6 months back before this court. Tell me.
8-1,
Eh, dia kita pun black book your nam likhu.
may sir.
No, you don't submit. What you have done is absolutely wrong. You have taken an adjournment earlier on the same ground.
Thereafter, I have sent the letter to the appellant, my lord. I have the
What?
letter, my lord.
No, you say Mr. Tisek, the learner, has informed this court that so-and-so leading the brief of the appellant has expired. He informed ILM that they are Iman. It is in a let's say correspondence as
Yes,
regards expiry of the lead counsel we conducted, lead so-and-so. So, what it did?
Thereafter, I have sent the letter, my lord, to the appellant, and they received and came, my lord, and signed the wakalatnama to conduct the
Today.
case. Conduct the case, my lord.
Today.
Today
When
I
did
have
you file the wakalatnama?
10:30, after mentioning, my lord.
Ah,
Since it
Mr.
is recess,
Tisek,
my
the
lord.
learned counsel submits that he has filed the wakalatnama today. Gustav, list the matter for hearing. Some people lied.
Yes, my lord, so many people, 3 or 4 people already, I have gone through the record, my lord, I have seen.
Then, over.
Totally not in this case. After, my lord, from that our senior, Mr. Profuller Roy was engaged, my lord, his name was there.
I can't help you.
Therefore, my lord, now.
So and
we will
so
do, my lord,
appear. Let the matter be. List the matter on 4th of August 2025, on which date? The 4th of August 2005. The counsel appearing on behalf of the appellant is advised to be ready with the hearing of the appeal.
I know.
LCR has not come. LCR has not come. LCR having not been received, the registry shall take appropriate steps. Next. What is this? FAO and CRP? Come, I'll get a due. Yes, Mr. Som.
Listen, I have just here village.
Who is there in the FAO?
My lord,
Ah,
after the injunction order passed, we filed this appeal, my lord.
ah,
During the pendency of this appeal,
hmm,
the suit was withdrawn. By the plaintiff.
hmm.
On 3rd of June. Then on 4th of June, an application was filed by the defendant number 7 and 9 on the order 23-182 for transposition. And that application was filed on the next day after. Then by the impugn order in the CRP, the learned civil judge, while allowing the plaintiff to withdraw the suit, also pass an order in respect of the petition filed by the defendant number 7 and 9, transposing them to the plaintiff in the close of the petition, and allow them to file their own pleadings in the suit. Also the court fees. So therefore, these complications. My lord is to
What is the suit for?
suit for declaration and recovery of possession, cancellation of the sale deed.
Suit for cancellation of sale deed.
Yes.
And who is the defendant number? 7 and 8.
I am for the defendant number 1 and 8. 7 and 8 are one of the co-owners.
7 and?
The father of the 7
No,
and 9.
who transposed themselves?
The 7, 9, the
They-
father of the 7 and 9,
Ah.
their father executed the sale.
No. Rafiq Hussain and Lucy Begum.
Yeah, they are the 7 and 9.
So they were transposition to as plaintiff
That's right.
against plaintiff number 1 and 2.
Yes, Jinnah Ali and
How was the transposition made?
that we challenge in the sale.
CRP.
And so far the FAO is concerned against the injunction order, our schedule is Schedule C. Now, the Schedule C, the no injunction was sprayed in the plain.
No, this injunction order has to be vacated.
Yes, absolutely. There is
This
no.
injunction order cannot remain taking into account that the plaintiff
Sure.
have not. This injunction order has to be vacated, taking into account the subsequent events without going into changing the nature and character of so.
The injunction order dated 11/3/2024.
In FAO, everybody is representing
My lord, I'm for the respondent number 1 and 2, the plaintiffs.
1 and 2.
They withdraw.
You withdrew.
Yes.
And what about the others?
Others, in the injunction application, others are not the party. In the injunction petition.
What about the performer?
No, they were not joined as the opposite party.
What do you
I
have
am
to
just
say?
corrected.
You are for that, those transpositioned. Do you have any objection in this? The injunction order being vacated? So therefore, you don't have any problem. Shalom. It has been submitted. The instant, this is an appeal filed under Order 43, Rule 1R, challenging the order dated 11/3/2024, passed in Mize case number 309/2023, arising out of title suit number 15555/2023, whereby the learned trial court, learned court of the civil judge, senior division Dibrugarh, had directed the opposite parties, that is the appellants herein, had restrained the opposite parties, that is the appellants herein, from changing the nature and feature of the suit land till the final disposal of the suit. Full stop. You are concerned with Schedule C.
I am not.
Full stop. It is specifically stated herein that the appellants herein are only concerned with Schedule C. Full stop. It has been submitted at the bar, and further apparent from the materials available in CRP IO number 210/2024, that in the meantime, the plaintiffs in title suit number 155/2023 have withdrawn their claims so made in the suit. And on the basis thereof, full stop. Further to that, the defendant number 7 and 9 filed an application under Order 23, Rule 1A,
No, they say 10A, but it's also being 1A.
1A, of the court for their transposition as plaintiffs in the suit. The learned trial court have allowed the said withdrawal by the plaintiff and the transposition of the defendant number 7 and 9 in the said suit. Full stop. It is further submitted by the plaintiffs, the original plaintiffs in the suit, that they do not want to further contest the said suit. Full stop. Mr. A.R. Som, who appears for the defendant numbers 7 and 9 in the connected CRP IO number 210/2024, also submits that he has no objection if the injunction order is interfered with. Full stop. Considering that the plaintiffs in the suit who sought for the injunction order in Mize case number 309/2023 is not interested in further proceeding with title suit number 155/2023, full stop. The question of allowing the continuance of the injunction order dated 11/3/2024, more particularly in respect to Schedule C to the plaint of title suit number 155/2023 does not arise. Accordingly, this court interferes with the order dated 11/3/2023 24 by which the appellants herein were restrained from changing the nature and feature of the suit land as described in Schedule C of title suit number 155/2023. Full stop. Appeal stands accordingly disposed. Yes, what is the CRBIO?
Now, in title suit, my lord, in that 155, my.
Yeah,
their
it is one
application was
year.
allowed.
Huh?
Page 64, my lord.
Now, with reference, I am of the consider with that insofar as the claim raised by the petitioners are concerned, it is indeed pertinent to reflect the petitioner to write a raise the defendant in the area and defend the legal age of the deceased Hasim Ali, who is also the son of the deceased Hassan Ali. And being so, the petitioners have got a genuine claim for their end. And with respect to the prayer made by them in the aforesaid suit, what they are challenging, sale deed.
But the originally the plaintiff was challenging the sale deed of the appellant number 1.
Appeal is finished.
No, that just defendant number 1.
You are defendant number 1 and 2?
1 and 2.
Okay.
So that they're challenging the
Sale deed of year?
of our sale deed is
'23.
yes. 8/10/2020.
Then why a fresh suit was not filed? It could have been filed within 3 years.
How transposed persons can file their in this suit, how they can allow to file their own pleading?
This is unheard of.
That's the order of the non-trial.
Unheard of. Is it heard of?
Yes, about lordship,
I would have considered, but taking into account that the sale deed is of the year 2023, you can very well file a suit if you want. You have to pay court fee, everything you have to do, then you have to file it.
so lordship, so that learned trial court, that last portion, your lordship, along with requisite court fee.
Understood.
objection.
Means it's like a fresh suit. Pleadings you have been asked to make.
Okay.
So, transposition cannot be in this manner, what he has given. No. Suit is state. Suit has been stayed. That order of transposition has been stayed. Chalo, we extend it till another date. Let me come back after vacation and being fresh and dismiss it and allow his petition. In the meantime, I think the best option is for you to file a fresh suit. No, I would have considered that the suit has been going on Now you get the benefit of the limitation. That is why I asked, what is the sale deed? Sale deed of the 2023. You still have the limitation. So the matter requires an early disposal, because if this matter gets delayed somehow, you may lose your right for limitation. Yes, there the problem is. That is why. You file- Huh?
Lordship, after vacation.
Oh, there are so many lawyers waiting. Huh? Chalo.
15 or 16.
I don't know. I'm sitting in this bench.
Then August.
No, I'm not sitting. I've asked the Chief Justice to change me. Yeah. Disposed.
Lordship. After vacation, Lordship.
It is in your, because of you, I'm thinking of disposing, not because of him. Because you need to file a suit. You have to pay the court fee.
That part may be observed here, Lordship, it's separate.
No, I'm allowing you.
Yes, yes.
You are at liberty to file a
Right.
suit. And by paying here, what he was, and if you want the question of transposition does not arise in this manner.
Yes.
Now, heard Mr. B. Dr. Dalani, Senior Counsel, assisted by Mr. S. Leka, Pustak, Mr. A.R. Som appears on behalf of the respondent number 1 and 2. And where's the other one? Come here. So and so appears for the respondent number 3 and 4. The petitioner herein have assailed the order dated 13/6/2024, passed in Mizze case number 152/2024, whereby the learned court of the Civil Judge Senior Division Dibrugarh permitted the respondent numbers 1 and 2 herein, who were the defendant numbers 7 and 9 in title suit number 155/2023, to be transpositioned as plaintiff in the said suit upon the original plaintiffs withdrawing the said suit without liberty. Pusto. The learned trial court not only transposition the respondent number, the defendant, the respondents herein, there's number 1 and 2, who are the defendant number 7 and 9 in the said suit, but also permitted the respondent, the said defendant number 7 and 9, to file separate pleadings and also pay court fee. Full-stop. The said order, in the opinion of this court, is contrary to the settled principles of law in respect to transposition of a defendant as a plaintiff. Full-stop. And more so, when the pleadings, when the said when the defendant number 7 and 9 were directed to file separate pleadings and to pay court fees. First of all, accordingly, this court interferes with the order dated 13/6/2024, passed in Mizze case number 152/2024. First, this court, having interfered with this order and taking into account that by another order dated 11/6/2024, the petition filed by the plaintiffs for allowing them to withdraw the suit was allowed, the suit being title suit number 155/2023 stands closed on withdrawal. Full stop. This court, however, observes that the defendant number 7 and 9 entitled suit number 155 oblique 2023, who is the respondent number 1 and 2 herein, would be at liberty to file a suit seeking similar reliefs as sought for in title suit number 155 oblique 2023. First. Done? এইটো অৰ্ডাৰটো এইটো এই অৰ্ডাৰটো কাৰণে সেই অৰ্ডাৰটো নাথাকে বুলি হ'ব হ'ব
Grateful.
এই চব
For last order, I was directed to file this substitution application. I've already filed it, but that is not on record.
Mr. G. Bhartwaj submits that the interlocutory application have been filed, however, the same is not on record. List the matter immediately after vacation along with the said interlocutory application. What interim order? Dead people? Respondent or plaintiff? Okay. List the matter again on 6th of August 2025, interim order passed earlier shall continue till then. What else here? In FAO?
Yes, LCR was called for. It was an ex parte order in guardianship.
Oh,
LCR has been received.
ex parte order for what?
Guardianship was granted to the mother. I am the father.
Son, daughter?
Son. Oh, sorry, daughter.
What is the age?
The present is, her date of birth is 2013. So it will be 12 years.
Taking into account that the LCR has been received, list the matter for hearing on 7th of August 2025 at 2 p.m.
Deeply obliged.
What is the matter about?
They have filed
Huh?
that was- the amendment, the application was filed that was rejected. Against that, they.
আগতে APA কৰিছে নে? LCR call for what is this LCR business?
Complete petition has been filed on me.
You are appearing for the sole respondent.
Yes.
Why the LCR has been called for? Amendment application. Okay, none appears on behalf of the petitioner on call. Mr. So-and-so appears on behalf of the respondent. For the ends of justice, the matter stands adjourned to be listed again on. There's no stay. Amendment was allowed.
Amendment application was rejected.
Reject. Stands adjourned to be listed again on 11th of August 2025. It is observed that if the petitioner is no longer, does not appear on the next date, appropriate orders will be passed. Steps taken?
Step taken, ma'am. But office note shows that, my lord, I have not taken.
You have filed the affidavit of service?
No, man.
Oh, then what is this?
5, 6 I have taken.
You have asked to take steps by Dusty?
Dusty service.
Then why haven't you filed the affidavit of service? You have to file, what steps you have taken? Ah, when did you apply?
5/6/2025.
You've submitted. And today till now you have not got it. Here the steps says steps be taken by the learned advocate by Dusty upon so have not been received. Then
I have
it is seen that the steps have not been taken by the appellant upon the by way of Dusty. Full stop. List this matter again on 8th of September 2025. Full stop. In the meantime, the counsel appearing on behalf of the appellant is directed to effect service by way of dusty upon the respondent number 6 and file an affidavit of service on or before 27th of August 2025. No, now new order, new dusty,
Well. Waiting for respondent.
an
one, two,
affidavit of service. huh?
apply.
22 হয়ে গেল না?
Order, justice service is complete. I have filed a affidavit, but it's not on record. So let this matter come up next week so that other side may appear because for day before yesterday only this justice service is complete.
Have you filed the affidavit of service?
Yes, I filed.
Mr. Argusami, the learned counsel submits that the affidavit of service have been filed. However, the same is not on record. List the matter on 30/7/2025. Interim order is there. You have urgency.
Yes.
37/2024. Full stop. 25.
Apply.
The registry shall bring on record the affidavit of service.
Make reason of.
Yes.
But in this matter, I mean, it's services complete.
Service complete?
3, 4, 5, 6.
What about 1 and 2?
1 and 2 died. And their legal rights are already represented.
Okay. The respondent number 1 and 2 expired. Have expired. And it has been submitted by the learned counsel appearing on behalf of the petitioner that their legal representatives are already there on record. And as such, there is no requirement for any substitution. Mr. N. Hawk appears on behalf of respondent number 3, 4, 5, and 6.
But daughters have not been included party in this case.
It's okay. 3, 4, 5, and 6. First. What is this matter for?
Well, no, already execution has been completed. And they have filed a petition for redelivery of the, my lord, that's technical.
Oh. Chalo. List the matter again on 18th of August 2025. Redelivery.
Wrongly done, man.
18th of August.
Too late. I love it.
A matter of 2024, you can wait and whenever this court takes up and then it becomes late. Yes, 25.
May I please your lordship?
Service not complete upon respond number 1, 2, and 3.
1 shows expired, 20 not complete, 4 entered appearance, and this shows the same family member, lordship, as far as records to.
What is this CRP for?
CRP for my appearance was closed, lordship, on the count of more than 3 occasions.
Stays there.
Stay is there.
Okay, sir. What about 2 and 3?
2 and 3 lordships, usual service also yet to be received, lordship, that is shows. I registered.
The service upon the respondent number 2 and 3 is not complete. Moreover, the respondent number 1 had expired. Mr. F.U. Balbhuya appears and submits that the respondent number 1 is duly represented. The estate of the respondent number 1 is duly represented by the other respondents.
Number 2, 3, 4 is represented, 3 is connected.
Who is the son and daughters of respondent number 1?
Separate person.
Huh?
Separate.
Then if respondent number 1 dies, how can you proceed?
Other person, maybe they are, but we do not know whether.
Has respondent number 1 expired or not?
Expired.
Then you have to take steps.
Yes, lordship, regarding sufficient.
Therefore, Mr. F.U. Balbhuya appears on behalf of the petitioner and submits the respondent number 1 had expired and he may be given some time to take steps. List the matter again on 13th of August 2025. Interim order passed earlier shall continue till then.
It shows that similar family members. with phone number.
There is no similar family member. There has to be a legal representative. No similar family. I'm not concerned whether any of the respondents are there. Next.
Obliged.
What is this RSA?
I am looking for response for 1 to 4.
And then
5 already started.
Yes, file a petition under 151 to modify the alter the stay order. First, under order 41 rule 5,
order?
41 rule 5.
Ah,
That I would not press, Lordship.
Mr. Swens Jeev was appearing on behalf of the respondents.
Yes, 1 to 4.
Respondent numbers?
1 to 4.
1 to 4. So submits that he would not like to press IA civil number 1096 of 2024. Taking into account the above, the said interlocutory application stands closed on withdrawal.
Lordship, respond number 6, 7, 8. They are the pro forma respondents and the pro forma defendants the suit. They did not contest. So their name may be stricken.
He can say, who are you?
If otherwise the LCR has been received, I would have
Okay.
On 16, 615, as per office note, neither AD or nor.
About respond number 6, 7 and 8, they are performer. Can we strike out their names? Gustav, Mr. S.R. Gogoi appearing on behalf of the appeal to Lekhibo. Ago to I kono likhini. Mr. S.R. Gogoi, the learned counsel appearing on behalf of the appellant submits that taking into account that the performer respondent number 6, the respondent number 6, 7 and 8 are performer respondents in the instant proceedings and they did not participate before in the trial, comma, their name may be struck off. So taking into account the above, the name of the performer respond number 6, 7 and 8 are struck off. And the counsel appearing on behalf of the appellant is directed to file a fresh memo of parties before the registry of this court within 7 days from today. The registry on the basis thereof shall make necessary correction in the cause title and update in the CIS. It is further seen that that the LCR have been received and all the other respondents are duly represented. Considering the above, the list the appeal for hearing in the usual course, liberty given to both the parties to file appropriate application for early hearing.
Thank you.
Obliged.
Affidavit of trustee on record.
We have filed.
Hello. Service complete. What is the matter about?
Matter, Lordship, the appeal was dismissed for default.
Oh, এখন দেখছুন যাও ভালো রে। It is seen from the affidavit of service so filed that the service have been affected upon the respondents, respondent on 29/4/2025 and an affidavit of service have been duly filed. Full stop. Considering the above, the service upon the respondent, sole respondent, is deemed to be complete. Full stop. Where is that order? It was dismissed for default when?
Dismissed for default on 5/9/2024.
5/9/2024.
Is 15.
So that he got the knowledge of the case on so and so fixing the year. Full stop. Taking into account the above, list this appeal at 2 p.m. on 20. We finish it off on that day. Petitioner affidavit has been received and none has appeared on behalf of the petitioner on call. Oh, but CIP, I would go. Yes, Mr. Lal, where is he? Huh? Mr. Lal? Not there.
They have come against the interim order also. They have approached this honorable court against interim order, Lordship,
Ah.
by the learned family court.
See, he wants an upgradation and he's nowhere to be seen. Mr. Lal,
Yes, my lord, in compliance of my lordship order, we have filed this as a certified copy of financial affidavit of both parties, my lord.
fantastic. By way of filing an additional affidavit, the certified copy of the area be filed by both the parties even. How much amount has been awarded?
10,000.
10,000, my lord, the meager amount 10,000 as an interim
As-
in 2023, my lord.
What do you do?
My lord, say, I do nothing, my lord. 50 years old lady, my lord.
The other person has got lots of money. You want
Yes, my lord.
enhancement.
Enhancement, my lord.
I remember. Yes, what do you have to say?
Was the learned family court under section 127, Lordship.
Ah.
That forum is there, Lordship. for
What?
Enhancement. My learned friend is submitting that in 2023,
Ah.
10,000 was provided, Lordship. Now, if one learned friend is on that, he will approach the learned family court, Lordship, under 127 CRBC, Lordship.
What is your income?
Lordship, that
What do you do?
now I do nothing.
He is a builder, my lord, builder and consultant, my lordship. He has shown in the financial affidavit, my lord.
I was engaged in a company. Now I am retired, Lordship. I don't.
You have retired.
I do nothing.
My lord, if you,
You are 64 years old.
64 and now 65 years.
Now 65.
if lordship kindly see his financial affidavit, a 29 years old son has been shown as a dependent, where he is a CA, my lordship, and his salary is 80,000. And he has shown the dependent in financial affidavit, a major son.
Please come in.
Earlier, the petitioner approached this honorable court by filing a CRP, Lordship. That was dismissed by this honorable court. Lordship may find the order at page 65 of the petition, Lordship. And the honorable court directed.
What car do you have?
He has two cars, my lord. The Kia car, he has shown loan from the bank.
Mr. Lal, first
Yes.
of all,
Yes.
moving on a car, you cannot appear.
I am
You cannot appear on a moving car.
my lordship,
First of all,
I am
remove him. Remove him
Yes.
from this video conference.
I am sorry, my lordship. I am moving towards here.
Absolutely not done. We giving you an indulgence to appear by way of video conferencing. Is this the state of affairs? None appears on behalf of the petitioner on call. Full stop. The council appearing on behalf of the petitioner was afforded the video conferencing facility. Full stop. It is the opinion of this court that if a video conferencing facility is provided, it is expected that the council maintains a decorum and not appear before this court on a moving car. Full stop. Under such circumstances, this court is not inclined to hear the learned counsel appearing on behalf of the petitioner. Full stop. Accordingly, the matter stands adjourned to be listed again on 28th of July 2025. What is this, Mr. Ahmed?
There is a delay.
How much?
448.
Objecting?
Yes, they file objection is there, madam. We have filed our objection, madam.
Are you objecting or not? Objection is different and objecting is different. One is a noun and the other is this adjective.
This judgment
The
is of
verb.
right.
Yes. Are we on the verb or the noun? Which one?
But verb line.
Verb, you're objecting.
Since we have already filed our objection.
Chalo. If he's objecting, we'll have it on some other day. Urgency?
Absence is there because let it fix.
Not next week, after vacation. To submit this matter with the delay of 448 days had been strongly opposed by Mr. Estes appearing on behalf of the petitioner. A respondent, taking into account that the matter would require a further hearing on the matter. List this matter again on 16th of July 2025.
Tomorrow I will.
Huh?
Tomorrow I will subject.
Please.
Hello.
Yes, what is this? Service not complete. Service complete.
Hearing SKB.
You are paying for it. 31, na?
Yes.
31 is late for orders. Okay, what is this matter about?
What happened?
Moi pass kora order hoga sir.
Under order 7.
Huh?
Page 19, Lord.
Oh? Should come up for motion.
Yes.
The matter has been wrongly listed for orders, comma. The registry shall list this matter for motion. Hey, Mr. Counsel, tell me, what is this type of petition? Tell me. What is this? Another petition file? Dusty service? No, what is this? Affidavit file? What is this file? CRPIO 7th of April?
46.
An application under 227 of the Construction of India? Huh? What is this?
The amended question. Published by the Honorable Court, I have
What are you challenging?
order dated Lordship on 2025.
It has proceeded ex parte against you.
Then accordingly, I have filed an application.
The defendant has filed a petition praying for setting aside the ex parte against him. However, the learned counsel for the defendant has failed to advance his argument when called for, and hence the court deems it fit to reject.
Kindly have a
For
look, Lordship,
non-prosecution, basically dismissed for non-prosecution. Remedy is there, Lordship.
Mr. Ali, kindly don't come up with this type of objections. Lekhok. What is the date of the order?
225.
One?
Impugn order in Lordship 1 to 25, the expert order in Lordship 11A.
I'm not going to do this. I'm only interfering with 1 to 2025. Thereafter, what the court does, that is their lookout. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. So-and-so appearing on behalf of the respondents. Pustak. The instant matter is, which has the instant matter is taken up for disposal at the motion stage. Pustak. It is seen that the petitioner herein had filed who was the defendant number 1 in the suit, had filed an application under order 9 rule 7 of the code for vacating the ex parte order dated 11/8/2022 and thereby enable the defendant number 1 to contest the suit. Full stop. The said application was registered as petition number 659/2024. Full stop. When the application was taken up for consideration on 1/2/2025, the counsel for the applicant, for the petitioner, did not participate. And it is under such circumstances the said application filed under order 9 rule 7, being petition number 659/24, was rejected on the ground that the counsel for the appellant, a petitioner, did not advance argument, comma, it is the opinion of the court that the learned trial court, if was not inclined to learned trial court, if wanted to reject the said application, comma, ought to have rejected on the grounds stated in the said application, on the ground as to whether the grounds stated in the application showed a sufficient good cause within the meaning of Order 907 of the Code, rather than dismissing it on the ground that the counsel appearing on behalf of the respondent, appellant, petitioner, did not participate. Accordingly, this court interferes with the order dated 1/2/2009-25, passed in title suit number 61/2021, and further directs the learned trial court, that is the court of the civil judge, senior division, Amingaon, to rehear the matter, rehear the application being petition number 659/24. Full stop. This court further, what is the next date fixed?
8/7.
Huh?
8/7/20.
So it is brought to the attention of this court that on 8/7/2025, the next date is fixed before the learned trial court, that is the court of the civil judge, senior division at Amingaon. Full stop. The learned trial court shall, both the parties shall appear on the said date and address arguments on the said application filed under Order 907, and thereupon the learned trial court shall pass appropriate orders. With the above, the instant petition stands disposed.
Thank you.
Service not complete. Stay. Why is service not complete? Validate, validate. Okay, we don't extend the stay. Then why affected not by the stay? Huh? What?
Used to accept.
Then why didn't you file the affidavit, the stay?
Fine, but that's 4/6.
Huh?
4/6.
4/6. It has been submitted by the learned counsel appearing on behalf of the petitioner that the affidavit of the stay have been duly filed on 4/6/2025. So, however, the office note says otherwise. Be that as it may, taking into account the said submission, list this matter again on 18th of July 2025. The interim order passed earlier shall continue. On the next date, the learned on or before the next, the registry shall, prior to listing of the instant matter, update on the status as regards the service upon the respondents. Delay. Delay? How much?
241.
You are contesting?
Yes.
Why?
Your Lordship, almost 330 days delay. And that too has not been explained. Only the thing is diabetes, number 2, and 53 days delay in collecting the judgment form.
Diabetes?
Various schedule will
What is the age of the person? One is to be sympathetic.
But 3 petitioners, Your Lordship.
Other side is bank.
No, Your Lordship.
Huh? Bank is stingy in giving everything.
3 petitioners, but 1 petitioner is 87, but other are 3.
We're going to list the matter again on 23rd of July 2025. On which date the application for condonation would delay would be considered. Forty-five? What is this? Oh, that matter. Then? Why you are filing? Because of that letter. But why you are not challenging that letter by way of a writ? Because you have no business out there.
Obviously, but we have.
Because you were not made a party. Are you not a company?
Company.
So if it is a company, the company has to be made by way of a registered affair. So what to do?
That the letter that we have rejected, not that fair, that we have also requested.
Ah.
They said that if we were not, if we
Have you written a letter to them?
also written.
That is not on record.
Not on record yet.
Then why haven't you brought that on record? Because you see, you are not, the problem which this court is facing is, you are not a party to the proceedings. If you are not a party to the proceeding, I am allowing you, and that is your basic basic defense also. Isn't that your defense? That you are not a party to the proceedings. But in view of the railway's letter to you, you have been compelled to approach this court, isn't it? So why you are not writing that letter to them?
Was not considered because they said that already court has part order, you have to challenge this order also. After that, we have.
No, let us assume today I pass an order. I condone the delay. What order can I pass? Tell me. Insofar as you are concerned.
Correct, Your Lordship, the finding of this court, person constitutionally false. Finding is not correct here.
No, finding is not correct, but the finding has been given vis-a-vis the appellant as well as the others,
Your Lordship,
not against you.
Your Lordship, remand.
But how do I do it? At the behest of a person who is not there. Give me the reason. How do I do it? Because that day I thought about it when you moved it. The only problem is if you had written a letter to them and brought it, then I could have got something, somewhere, some handle. You are not giving me the handle for that. And the railway says that no, you have to pay. But they have not written a, you just brought in the railway has given this letter, I am coming. How do I take care of it?
Exercise has to pay. After that, they have filed this petition, after that, order they have submitted, then they have.
Then why you are not filing it? Why you are challenging this if you have nothing to do? Because the moment you are involving yourself, you are becoming a party to the said proceedings.
Order I have submitted before the authority, then they have that. Yes, they have challenged. That's why they have stopped.
You write a letter to them, railway, and then bring it, or if you have any letter, bring it by way of an additional affidavit. I should get a handle somehow. Okay, Mr. S. Islam, the learned counsel appearing on behalf of the applicant submits that the applicant would file, would submit a communication within 7 days from today to the general manager, NF Railway, that the NF appellant have nothing to do with the respondent number 2, na? Respondent number 2 in the instant appeal. And that the said award so passed by the learned commissioner has nothing to do as regards the appellant. First, list this matter again on 6th of August 2025. In the meantime, the respondent appellant applicants shall bring before this notice as to what transpired upon submission of such communication, if so submitted. You furnish that, then I get something to do it.
Publish.
45. Yes, what is this? Huh?
Difu to Lakhimpur, my lord.
Yes.
Other than my lord,
Dipu
to Lakhimpur.
to Lakhimpur. Then,
Applying for the wife, my lord. Primarily on two grounds, my lord. Financial grounds and other thing is that traveling from Lakhimpur to Difu is quite difficult on the part of the wife. My learned, your colleague has appeared and contested by filing an affidavit. What I humbly submit, my lord, she has some difficulty in traveling to Lakhimpur. I have the difficulty traveling to Difu, my lord. Can it be transferred to?
you stay in Difu
I stay in
I
Lakhimpur.
or you stay in, you are the lady. Okay. Then,
Can it be transferred to Tezpur? Sunitpur?
Tezpur. How do I have it in Tezpur? Hindu? Last resided? Where? Marriage?
It is Lakhimpur. Lakhimpur.
Okay. The next one is where the defendant resides? Lakhimpur.
Defendant, she's defendant. I
Lakhimpur. Lakhimpur.
Lordships. Only one page, page 95 of what I have filed today. It's for your lordships. Lordship will see this is nothing less than a Sonam Raghuvanshi. The only difference being that I did not die. Lordship will just have a look at what she and her father have done to me.
Huh?
Lordships will, this is what they have done to me. This is the assault which was
No.
Which
I'm-
was-
I'm.
This is the assault which
repeating
was done on me, Lordship, at the instance of my wife and my father-in-law in Difu in my house. This has happened to me in my house. Lordship, kindly page down to page 97. I received 15 stitches on my head. My little finger of my left hand has been amputated. It was that grievous an assault, and the case is pending before the Difu courts, Your Lordship. That criminal matter.
My lord,
And also, if I do not know whether my learned friend is aware or not, my
Who
wife,
stays in Difu?
I stay in Difu.
Okay.
And she, her father assaulted me black and blue, as your lordships can see.
I'll respond.
Let me just- Let me just finish in that case, lordship. There are, at the instance of my wife, she has now, again, there was a problem with me and my colleague. I am an assistant professor in the university. And at the instance of that colleague, she has now also instigated two girl students to file cases against me, which are also pending in Difu. And she's also filed a case against me in the Assam State Women Commission, where she has asked for alimony. So the entire case, and I have now got to know that this is her third marriage to me.
No.
Yes. Yes, your lordships.
I have
It
the-
is her third marriage to me. And I have also, and in fact, now for the purpose of alimony, she's not realizing it. She's sending me conversations which she has had with my colleagues, asking the draft a petition with AI and take alimony, thinking that perhaps I will settle the matter now. So I have all of this electronic evidence, and now that the suit is at the trial stage, when I have already filed my evidence in Difu, and it is now that she has come at this belated stage to get this transfer. Lordship, my only submission before your lordship, there is a judgment of the Honorable Apex Court, 2017, which I have also mentioned in my affidavit. This is Krishna Veni Nagam. I'm just tracing it before your lordship, where it says that if the parties have difficulty traveling, one party should be given the option of video conference. She did not come. And the Difu court is competent and your lordships are aware that they have video conferencing facility. Let her not travel. Let her appear by video conferencing. No, everyone's purpose is served. She says that there's a threat to her life. I am saying there's a gross threat to my life if I travel to Lakhimpur, your lordships. I would be completely and totally, your lordships have seen in Difu they have done this to me, where I say, what would they do to me if I may
My lord, there are many allegations against this person, my lord, and the local people of Difu, whatever injury has been caused to him, it was done by the local people. Me and my father was forced to leave, and thereafter some people entered the place and
Absolutely
These things
incorrect. I'm carrying the certified copies of the statements which are being made before the trial court, your lordship. That also I am ready to produce before your lordships. It is with great, absolute. I normally would not have lordships. I'm completely aware of the law so far as this entire thing is concerned. But it cannot be that the wife has always needs to be accommodated, especially in circumstances when she has done such a grave act, your lordships. There has to be I'm submitting with this with grave, with full responsibility.
But madam, tell me, in Diffu only you had this problem.
Lordship, that's what I'm saying, that they both my wife and my father-in-law, they hired a young boy to come and beat me up black and blue. I opened the door and he just started beating me. And then my father-in-law came and checked after he had injured me, after he had bled me to almost till death. My father-in-law comes and slaps me once again, checks whether I'm breathing or not. And then both of them run away. They abscond. They just go away to Lakhimpur. That is the story behind. And I'm carrying the certified copies of witnesses who are saying it in the criminal trial. I can produce it before your lordships. That this is the exact thing what I'm telling your lordships is exactly what has happened. Other witnesses, my landlady who took me to the hospital, my landlady's daughter who tried to stop that man from beating me black and blue, everything. So I would not have objected otherwise, your lordships. It is with great responsibility that I'm saying this. He does not know about the facts. The facts are in what is happening to me over there, your lordships. They have maligned me to hell and back. This lady and her father, they have instigated all these cases against me. Fishing forum.
You are asking for divorce?
Yes, of course I'm asking for divorce pursuant to this.
Kind of cruelty.
Yes, physical and mental.
Stay in Lakhimpur. In both the places, there is no family court.
No, it is before the district session judge. It's pending before the district session.
But there is a difficulty because the area, this very distance is very far.
Yes, your lordship. That therefore, and
One is in Diffu, one is in Lakhimpur.
And also because of the cases that she has instigated against me, now I'm under suspension now, which is also something which I have put to challenge here. Now, I filed a petition. It is yet to be moved before this honorable court, but I have filed a petition challenging my suspension as well, your lordship. So all of these.
What do you do?
I'm an assistant professor in the Diffu, in the Assam Silchar University, Diffu campus.
He's placed under suspension not on the basis of my allegations, madam.
Oh, yes, of course. She has also filed. He's not aware.
No, no,
Yes.
no. There are many allegations against him, madam, regarding all this.
Everything pursuant to this attack, your lordships. Everything has happened pursuant to this attack. And the only reason why all of this happened is she wanted alimony from me. That is the only ground. That is the only thing. Like I have said, this is her third marriage. I don't think my learned friend is aware of it. If he goes back to his client and finds out, he'll understand this is his third marriage. The second husband died, by the way. That is my information. Now, I do not know. I do not cast any allegations. It's a
What is the first husband?
First husband, I'm told that was a marriage when they were not teenagers. They were both minors. That was when the first marriage was consummated. So.
It's not that she is married 3 times. Means and with although there are 2 existing marriages, it is not that.
I have taken specific instruction. My colleague who has engaged me, madam, he upon inspection told me that there was no marriage as such. In fact, the sister of this petitioner was starting at Diffu, through whom this respondent and the petitioner hearing came into touch, and after that, had a love affair, then married.
Yes, her sister was a student of mine. That is how the entire marriage was arranged. And that is how I married her. I'm not denying that at all. But the fact remains, that interestingly, I also have evidence now, which I'm producing, which I'm trying to produce before the learned district and session judge in the divorce case.
She doesn't have any money.
Lordship, I am under suspension. She is trying to get alimony from me.
She
I-
has no money. Does she work? You get something on suspension also, you
I
get
do get
something.
yes.
Pay
And I'm-
5,000.
Lordship, why not video conferencing the lordship?
5,000.
But no, she said.
Whenever
there's
she
a-
has to appear, she will pay 5,000.
Lordship, I am paying, Lordship, will kindly accept the fact
Pay
that she is
5,000
also,
whenever she has to appear, not on this. Pay 5,000. Or go to. not
they
to-
already have counsel there appearing on her behalf. She's already engaged someone. Someone is always appearing on her behalf.
Normally, it is not required. Whenever she has to appear, you have to pay 5,000.
That's very harsh.
No,
Lordship,
it is not
done
hard.
with- what she's done. to me.
Otherwise,
That's
accept the other one.
Lordship, video
Accept the other one. See. You go and appear. You also have a counsel.
cannot go.
Yeah.
I kind so perhaps accept my prayer that video conferencing will be allowed.
Either 5,000.
She does not.
No,
need-
no.
Not
She has
5,000.
to appear. If she has.
If she has.
No, no. The question is, you may very well say that her appearance is not required. Like tomorrow, she has to come and file her evidence on affidavit. Tomorrow, she has to come and file her, what do you call, the written statement, and she has to sign. Tomorrow, the court wants her that she has to appear on this date, on person, then you have to pay 5,000. Well, if the court does not require, it will be done to the lawyer.
Alright.
চলো কাৰণ এইটো মোৰ এনেকুৱা judgment আছে যে আগতে 3,000 আছিল এতিয়া 2,000
Should we take
5,000
considering my
this time I'm not transferring it, let it be there, but 5,000 whenever you appear, have to appear.
I'm
এইটো
ready.
section 13 লগাই এইটো আমাৰ judgment আছে হা section 13 লগাই and
There was an interest.
the interim will be vacated and he will file the written statement on you will not file.
Cross. Five stage. It's at the stage of cross examination of my witnesses.
The case is in a very fast track mode, my lord. Witnesses are framed on 21/2 and
Huh?
thereafter
You arrived when?
have arrived 19/5 and the witnesses were framed on 21/2 and the next date was fixed.
At the stage of process, this court inquired with the learned counsel as to why the transfer is being sought for at such a late stage. On behalf of submitted, there is a threat perception upon the petitioner for which the petitioner fears to go to Karbi Angan.
Lotships have already seen the threat perception on me.
25 my lord, issues were framed on 21/2, my lord.
No. I have duly mentioned,
Yes, my lord.
not inclined to stay the proceedings on the basis of such averments again the petitioner had all along past there. Be that, no, I did not stay it. I requested the court to adjourn it on Thursday, which is the next
It
day.
was in fact fixed on Friday last, and the honorable court said, fine, we will take it up the Friday after, because
When is the next day?
20th, day after tomorrow, your lordships. Day
Yes,
after. That is why I had
Okay.
come to your lordships.
Okay, we'll have it on then, it will be on 4th of July. American Independence Day,
Lordships, not.
4th of July
I
before.
I have
Karbi Angan.
difficulty.
Why do you need a counsel?
Lordships,
Oh, you are going there. You need a legal counsel.
Fourth of July.
No, no, 5,000 is also gone. Yeah. If he can engage the counsel from Guwahati,
And I am told by
you are also appearing there.
one unsafe.
So whenever you appear every time. Take 5,000 each. Okay, we'll have it on 7th of July.
Here, again, here,
No.
Ah.
Karbi Angan.
lordships, may kindly keep it after 9, your lordships. I have personal difficulty, I will not be there, your lordships. Either on 11th,
11th.
11th.
Whenever you appear, 5,000.
Deeply obliged.
No video conferencing business. 5,000 units. Yes,
Deeply obliged.
okay, 47 days. Yes, what is this?
But as per last order, we have taken steps, my lord, but we could not file the affidavit regarding that.
You have not taken steps?
Yes, we have taken.
Trustee,
Trustee have taken steps, my lord.
affidavit of service?
Affidavit is safe, we need some days, my
Some
lord, to
file-
file. Because, my lord, yesterday it was attempted to start them, my lord, they were not there.
Huh?
Tomorrow again, we are attempting to start with them. That is,
We've seen that the service have not yet been affected by way of the stick,
we have,
in spite of the order passed by this court on 23/5/2025.
submitted on 25, my lord, that 25/5 we have submitted it to the registry, and we have taken it on the 6th of June, my lord, and thereafter we have sent it to Kachar district, my lord. And yesterday it was attempted, and the parties were not there at the house, in the house, and again tomorrow, my lord, it will be attempted to.
List this matter again, you have to take fresh steps now. On 11th of August 2025, the council, the appellants, the petitioner is directed to take fresh steps by way of the steel routed through the registry of this court and file an affidavit of service on or before 4th of August 2025. It is observed that if no affidavit of service is not filed on or before 4th of August 2025, this court would not be inclined to continue the stay. Interim order passed early shall continue till the next. Dear. Yes, others may go. Yes, what is this matter about?
Filed an application on section 10 for stay of my second suit, but that was stayed. Only against that. But my first suit was for partition of the share of the land. Then the
Well,
defendant.
Madam, this will require some deliberation. It is not so easy. Section 10, one has to look into it as to whether it should be stayed or not. It will require some deliberation. It is a different thing. It may be a case of joint trial is another thing.
For joint trial, but by this time, Lordship, the first suit attained the stage of cross-examination of DW. They have submitted.
Cross-examination of DW. And yours say, and the second suit?
Second suit, they have filed written statement.
Huh?
They have filed written statement. Second.
Would there be requirement of transpositioning the evidence in both cases same?
My lord, the defense which was taken in the first suit for partition was that Mr. Abdul Wahab, who was the main owner of the property, he had gifted the property to his wife. Wife has subsequently made a will during the pendency of the first suit. She passed away. During that point of time, she had made a will in respect of a portion of that property. There were as many as 6 schedules made in the first suit. In respect of 3 schedules, we have already stated in the written statement that we have no objection if those are partitioned. Now, after that was amended, the written statement was amended and these facts were brought into the picture regarding the gift deed as well as the alleged will which was made during the pendency of the suit. Thereafter, the petitioners had preferred the second suit before the same court, Civil Judge Senior Division, Goalpara, challenging the validity of those 2 instruments.
Cancellation.
Will as well as the gift deed.
If Lordship give date goes, then we.
Then, my lord, we, at the time, after filing a written statement, the respondent number 1 had preferred an application under section 10 of CPC, and that was ordered in favor of the respondent number 1, who is the defendant number 2 in the suit.
But wouldn't there be a problem? Just for example, tomorrow you get a decree also.
Well,
if you get a decree, on the basis, you will have to get a decree now on the basis of what? The gift deed?
Yes,
gift deed, my lord.
Now, the gift deed is not the basis in your plaint?
No,
Who
I-
has filed the first?
I have filed the written statement in both the cases, my lord. I am the defendant.
Who's the plaintiff, Lordship?
They are the
So
plaintiffs in both.
Who has given the gift deed?
Gifted, the original owner gifted the
Now,
land
defendant,
He is my father as well as the petitioner number one's father.
so they have given a gift deed to whom?
to one of the plaintiff and two defendants. Lordship. Mother gifted the land. Lordship.
The
Mother made a will.
mother
Lordship.
made a will. His father gifted the land to the mother.
Original
8 acres
owner
of land.
gifted a portion of land in favor of his wife, Lordship. Later on, that wife, mother gifted that property in favor of one of the plaintiff and two defendants, Lordship. We are denying that fact. We are saying that Abdul Wahab was the original entire property that has to be purchased. So, Lordship, second suit, I have prayed cancellation of this, Lordship.
My lord, the issue
And the learned trial court says, Lordship, as already the issue was framed in the earlier title suit, so the second suit has to be stayed.
issues were framed in both the suits, my lord. The issue number 4 particularly pertains to the gift deed as well as the
But
will.
Lordship, the cancellation
was-
claim
this
is
is-
not.
So therefore, if
If
we
this-
can bring this suit, the second suit, because all are being filed by the plaintiff.
By the petitioner's case, my lord.
The plaintiff,
Plaintiff in the
both the plaintiffs are the same.
Same
So in the first suit, the suit is for partition.
partition.
Now, during the pendency, there is some devolvement of the right on the basis of a gift as well as the will.
Gift was prior to the suit, my lord.
Yes, Lordship.
The will was made during the pendency.
Pendency and there was a gift.
There was a gift prior.
So, but in that gift deed was not challenged in the first suit,
No,
No,
my lord.
although they knew it.
No, Lordship, we came to know.
It was
after
made by
detailed
our
statement.
father, my lord. It was made by our father. It is our contention, they knew it.
So you say that they knew it. Because there is then the question again arises, whether by way of a second suit, are you legalizing the relief which has not been claimed in the
My lord,
first
they
suit?
have filed the second suit as well.
Therefore, what they are trying to do, one can very well, because if I allow it, means I am by way of another suit permitting a gift deed which ought to have been challenged in the first suit. That is, have not been permitted, have been filed in the second suit. And they are bar under order 2, rule 2 would be there. Don't you think so?
We came to know after filing the written statement. Lordship. It is our contention.
It would be my submission, my lord. It could have very well been amended and the prayer could have been asked.
Anyway, so therefore, that first suit and second suit. So the second suit that can be brought in and brought to a stage of evidence. Now, would that be again amounting to, then it is for cross of DW.
Process of
Yes,
DW.
DW is on submitted, Lordship. Next date is on.
There was
15th.
no stay.
No,
The
Lordship.
second suit was stayed, my lord. The first suit is.
No, here there is no stay to the
No,
first
here
suit.
is no.
Stay, Lordship, but while issuing notice, no stay was done.
Then how do I help you?
Lordship, this, Lordship, joint trial can be given, Lordship.
But the joint trial means, you see, the complications are a
No,
lot
no,
more.
when we- Joint trial is.
No,
to be very
see the complications. The moment I give you the joint trial, I allow you to give again evidence. You will be filling up the holes which were there or the lacunas which were there, which you could not fill up in the earlier suit. Isn't it? There are a lot of complications now.
And Lordship, the order which was passed, it says that already the issue is there in the previous suit. But Lordship, my prayer was not there for cancellation of the gift deed. It is required, it's a gift deed, Lordship. So for cancellation of the gift deed is required. Lordship. That was not there in the earlier suit, only partition suit that is
But the first suit is for partition.
partition. And they are claiming some.
And
portion
then
of-
they say that, you see, there is a gift deed, where is the portion of partition of these portion?
is
And
not-
the second is, they say that subsequently, there is a will which has come into being, and the will has not been probated.
Will not provided.
Then what is the value of that will?
My lord, section 213, I would rely on.
Huh?
213(2), my lord, of the Indian Succession Act. The Mohammedan will. I would
Oh,
argue
it is the
that.
Mohammedan will.
Yes, my lord. I would argue that. Probate.
the gift deed, the defendant number one. Necessary to question that gift deed, Lordship, and only after written statement, we came to know that Lordship gift deed was executed. As because in the earlier claim, there was no mention of any gift deed. Lordship.
Is there a will in concept in Mohammedan? Well, as per the Mohammedan law?
Of one third of the bequeathable property.
No, 1/3. I'm only answering whether there is a concept of a will in Mohammedan law.
Yes.
Yes.
Yes, there is a concept of a will.
And in Mohammedan law, it says that Lordship, probate is not necessary. Probate will not be required.
As per the Mohammedan law.
Only Lordship, page 63. Your
In
Lordship,
fact, yesterday I was looking into a judgment of Justice Pardiwala, which goes in fact against you in another case. You remember the case pertaining to section 97?
yes, Lordship.
There, one of the first substantial question of law so framed was as to whether the daughter would get 50% of her share. Now, I did not decide that, taking into account that I remanded the matter back. But in a very recent judgment, the Supreme Court was dealing with the similar question, wherein it says as regards the Mohammedan law, if there is a daughter or son, whoever is there, and there are predecessors, son of a predecessor and all, that concept is not is foreign. Because if I remember, the facts in your case were, the daughter was the plaintiff of Sahar Ali, and the other 4 sons died prior to the death of the father
No,
or son.
no.
But anyways, that was the case.
In that case, Lordship, the legal heirs will not be entitled for any share, that as per Mohammedan law. If the son predeceases their father, then they will not entitled for any share. But here in this case, she categorically in her claim mentioned that my father died leaving me and
And the
brothers.
4 brothers.
So according to the share comes.
So therefore, their sons, their shares
Yes,
have
Lord.
come. But otherwise, it is not there.
If
And the Supreme Court relied upon the judgment of a 1905 Calcutta High Court on this aspect. It's a very recent judgment. This judgment is on the question of whether there will be a res judicator in every proceedings of the suit. That was the issue. And another issue very pertinent is, if a person is impleaded by an order of the court, he cannot be removed later.
Yes, Lordship, that striking out the name of the legal heir who have already.
So there only one paragraph is mentioned about this. Anyway, so that was not there. I always thought that.
Here,
Mohammedan law is always new. Anyway, so this is a case where
here it says, Lordship, the while allowing their petition, the learned trial court has recorded that the core issue in both the suit are same. Issue number 4 in title suit in previous suit, that whether late Abdul Wahab executed a gift deed on so and so property in favor of defendant number 1. There is no quarrel, Lordship, about this, but only question is, it is the duty of the plaintiff to pray for cancellation of this gift deed as soon as they know about, they were aware about this fact that there is a gift deed, Lordship. So the second suit was filed. It could have been done by amending the plaint also, but Lordship, they have already filed a second suit. While issuing notice, I prayed for joint trial of both the suits, Lordship. It is 2020 matter.
when is the next date fixed?
15/7.
15/7, they have, after a long time, they have deposited the DWs as per information. And 23/5/2025, they have deposited the DWs, and 15/7 cross of DW.
Hello? We take it up on 23rd at 2 p.m.
Lord.
I pass the order. I only worry to that effect, because Yes, it is a case. In fact, what they should have done is they should have sought for amendment of the claim. Instead of doing it, they filed the second suit.
Madam, then the difficulty only arises as per Niemans is that if this issue is decided in the first suit in my favor, the second suit goes away.
No, the suit cannot be decided in your favor because it is his suit.
My lord, just the issue is the gift deed is, because the issue was framed whether late Abdul Wahab executed gift deed on 21/3/2008. If this issue is.
That issue is there in the first suit.
First suit as well as the second suit.
So then obviously the court should have gone for analogous. What is wrong with this court?
And there is no.
Correct,
problem in-
This court should have stayed this.
Not-
The problem has arisen because of 4 years. Hello, we'll pass orders on 20, when did I want? 23rd.
23rd.
23rd at 2 p.m.
Apply.
And madam, no more of these type of matters before vacation.
One clear matter, 48, my lord. Though it is state in hearing, my lord, I filed an application for early hearing, but in the meantime, they have filed a substitution petition on this case, so it may come up for order.
Item number 40.
48. I have mentioned for listing for orders also,
Item number 48 lists the matter for orders on when.
because I have some urgency, that is why I am filed early hearing. That was allowed.
Let's have it after vacation
Straight after vacation,
for orders on 16th of July.